of law even more. To the students here, I say to you, learn, ask questions, challenge, and own your future. To the press, I say, do amplify the truth. To all my colleagues here, remember why we serve. Ladies and gentlemen, welcome truly to the 4th edition of the CO ANAH SAN Memorial Colloquium. Thank you very much.
You'll notice I had to come back to the stage because I was advised to raise the mic for Ada because I'm very down to earth, literally and metaphorically. She's a bit in the sky, so she struggled for that to happen, and I apologize to her. When I'm leaving now, I'll be mindful enough to raise the mic so that I don't humiliate those who were greedy enough to take too much height that those of us coming from behind didn't get enough to take. Thank you so much, Ada. That was a lovely tribute, and we're grateful for your dedication to the legal practice and to the advancement of law in general. We are so grateful for that. When I got this program, I was I came here ready for war. I was telling a friend of mine this morning that I needed to buy some bags of pure water and put in my trunk because of the fire that I'm expecting here. Our lineup of speakers are energetic, they are powerful, they speak truth to power, and they are unafraid of anybody. And I would encourage everybody to please prepare for that. But before we proceed, let me employ and encourage everybody that is here, particularly those sitting on the other sides, if we can fill up the middle line so that the hall is not too scanty for photographs. Thank you as you do so. So I'm going to start off now with taking goodwill messages from leaders of other of the branches of the MBA. Because I skipped my boss, permit me to start with my boss. Let me start, first of all, with the past chairman of the Gariki branch, Bulus Atsin, to come and give his goodwill message. Ogasa.
I'm not down to earth like the MC, so I'll raise the mic a bit. Good morning, all. It gives me great pleasure to be here this morning. First, permit me to start by congratulating the ANAH Center for being consistent in the organization of this colloquium. And as you all know, the array of speakers that have been marshaled out for today's conversation are seasoned personalities who don't dabble into theories only, but have been practically involved in advancing the cause of justice and human rights in Nigeria and the world at large. So I want to congratulate us all for being present today. Permit me to recognize the presence of my leader and my mentor, Professor Chidi Odinkalu. Yes, sir. Yes, sir. Thank you for all that you have been doing to clear the path for those of us that are coming from the rear to see and follow suit. And we look forward to all that you have to contribute in today's conversation. Thank you all.
Thank you very much, my boss. Next, we're going to be having a goodwill message from the leadership of the Nigerian Bar Association, represented, I'm made to understand, Grace Igio is representing the General Secretary of the Nigerian Bar Association, Ojibara. Grace.
Good morning, distinguished guests, colleagues, and friends of the bar. I'm here wearing somebody else's helmet, and honored to represent the General Secretary of the NBA, Dr. Mobology Ojibara, who regrets his absence, and he has asked me to convey his and the NBA's unwavering support, for this vital gathering. He has further said, I should let you know that the NBA leadership has been impressed by the organizers and organization of this colloquium. It's been consistent, this is the 4th year, and he admires the consistency in hosting the colloquium. He thinks, or he believes, that your commitment goes beyond remembrance. It's about driving concrete legal and institutional reforms within our profession. And he can see that you are upholding the legacy of Mr. CEO ANAH SAN while attempting to build a stronger future for the law. The establishment of the ANAH Center for Social Justice is a necessary step in this direction. It embodies Mr. ANAH's lifelong pursuit of justice and social impact. The NBA eagerly anticipates the center's contribution to bridging the gap between the legal doctrines and practical social justice for ordinary Nigerians. We are excited, that is the NBA, to see the ANAH Center advocate for substantive justice that's accessible to all. Mr. ANAH's legacy demands nothing less, and the Nigerian Bar Association stands firmly alongside you in this critical endeavor. Thank you, and may this 4th colloquium inspire us to build a more just society. Thank you all.
Thank you very much, Grace, for that very thoughtful message. Now we're going to take more goodwill messages. I will start, of course, with my Lord, the Honorable Justice Alaba Ajile. My Lord. You're most welcome, my Lord. Later on, my Lord has a speech to give, but before that time, we'll just let him give a few words of goodwill.
Actually, I thought my goodwill message will be embodied in my speech. But now, calling me to make a goodwill message, well, I have to say something. First, to congratulate the CEO ANAH Center for this wonderful program. And I can see the efforts that Ada is pushing into this program. And I want to specially acknowledge her and to thank her, yes, for keeping the legacy of her father on. And well, this year, the topic has been carefully chosen. And looking at the excluding myself, looking at the array of speakers, having somebody like Professor Chidi Odikalu, having somebody like Aisha Yesufu, I really wonder what I am looking for in their midst. I don't know. They are all known as activists, but I don't know how I have been elevated to that level that I should be part of them. Well, I say congratulations. We meet when this is my turn to deliver my paper. Thank you very much.
Thank you very much. I'd like to invite the highly revered Leonard Silk Ikechukwu Ezechukwu to give his goodwill message.
Good morning, everybody here. I must say congratulations to CEO ANAH Center, powered by Adeze ANAH. This is the 4th year consistently of having this colloquium. Those of us who know CEO ANAH in person while he lived know him as a stickler to rule of law, as a stickler to procedure. If you have had the opportunity of reading his works on evidence, you will attest to his being detailed in whatever he did while alive. I congratulate all of us. I've seen the list of those who are going to talk to us today. I'm sure we are all very, very ready to listen to Professor Chidi Odenkalo. We know him very well. He's a person that fears nobody. He speaks truth to power. If you always visit his Twitter or X page, you will attest to what I'm saying. And then to our own sister, Aisha Yesufu, is it Ovevekuve? We know what she can do. She doesn't fear anybody. And we are very ready to benefit from what they are going to tell us today. They are going to speak truth to power. I wish all of us here a successful colloquium. Thank you very much.
Never mind that I'm moving around a lot. I'm trying to clock my 10,000 steps for the day, so I don't become so fat and lose my suits to other things. Next up, let me invite my boss, Paul Harris Ogbole, Senior Advocate of Nigeria, for his goodwill message. The next talk.
Thank you very much. This is a gathering of lawyers and non-lawyers. I hope you will not question my dressing attire today. But I'd like to say that I'm highly honored to pay respect to our special guests and invitees here today. My Lord, the evidence himself. Some would like to qualify him as the electronic evidence himself, Justice Alaba Ajilere. It's a great thing to see you still very, very active in law and the intellectual space, even after retirement. It will be a pleasure to learn so much from you here today. Professor Dinkalu, the irrepressible Professor Dinkalu, an academic and an advocate. My elder brother, Leonard Silk, Ezechukwu, our leader and father, chairman of my branch, the Unity Bar, former chairman of Gariki Bar, Chief Madaki Ame, who himself is the Okaleya. I think I'll just stand on the protocols established so far. I'd like to associate myself with Adeze ANAH and the family of CEO ANAH. I'd like to congratulate you for the good work you're doing, keeping the flag and the flame of our father, CEO ANAH, alive with the 4th edition of the colloquium. We're proud of you. You've done so very well for your father and the legal profession. He will be so happy and proud that he has a daughter who is actually flying his flag many, many years after he has gone. I have the 1st and 2nd edition of Evidence in Action by CEO ANAH. In fact, the 2nd edition was autographed, either 1st or 2nd was autographed by himself personally. And I feel very happy and I'm improved having used and read that book again and again. So he's one of the legal titans in the area of evidence that has graced our planet Earth and our country Nigeria, and indeed the legal space. We've been told so far from what we have heard about his contributions to humanity, law and practice, and his principles. These are principles that I think we should try to imbibe and use him as a reference point even in his death. I'd like to say that having read the 1st and 2nd edition of the book, Evidence in Action, I will enjoy all that will happen here today with the likes of Professor Odinkalu, and I hear the very, very powerful lady Yusufu is in the house, so I'm sure I'll also hear a lot from her and our other colleagues here. But I'd like to say specifically that I would want to make a request today. I was sounding it out to my brother a moment ago, Ezechukwu Ikechukwu, that the time has come for us to have a revised edition of that book. And I'd like to throw that challenge to our sister, Adeze ANAH, that book will be revised, that should be revised and updated in line with the current changes in the law of evidence, without losing the substance of the main original text. I believe it's something that can be done so that younger generations and people who are using the current Evidence Act as amended will also enjoy the benefit of the beauty, the prose, the law of evidence and action as originally written by our father, CEO ANAH. That is my appeal, and I hope that will form part of our discussion here today. But I thank you so very much that I'm honored to be in our midst. God bless us as we enjoy the colloquium.
Thank you very much, Leonard Silk. In case you did not notice, he has added 10,000 naira to your book's budget. For those of you that are trying to buy new books, so get very much prepared. And I really encourage Adaeze to take up that challenge and revise that book. I also read that book too. It was very good. And I like when I read from lawyers who are in practice writing books. The insights are very rich for those that are also in practice. Next, let me invite my sister again to give us a goodwill message. The Secretary, MBA Nyanya Caro Branch, J. Judith Olise, to give us her goodwill message.
Thank you very much. Good morning once again. Please permit me to stand on the already established protocol. This goodwill message is on behalf of my chairman, Sir Augustine Ibolo, KSM, the chairman of the MBA Nigerian Bar Association, Nyanya Caro Branch, and the entire executive committee. It is with deep honor and great respect that I extend my heartfelt goodwill at this 4th edition of the CO ANAH SAN Memorial Colloquium. This gathering is not only a tribute to the enduring legacy of a distinguished jurist, Chief CO ANAH SAN, but also a powerful reminder of the sacred role the judiciary plays in the protection of human rights and the sustenance of democracy. The theme of this year's colloquium, Independence of the Judiciary and the Guardianship of Human Rights, is both timely and necessary in an era where democratic institutions are constantly tested. We must continue to reaffirm the judiciary's critical place as the last bastion of justice and a shield for the voiceless. Chief CO ANAH SAN was a man of impeccable integrity, uncommon courage, and profound wisdom. His legal legacy challenges us to rise above mediocrity and uphold the rule of law without fear or favor. May his life continue to inspire a new generation of lawyers, judges, advocates committed to justice, equity, and truth. I commend ANAH Law Practice and the ANAH Center for Social Justice for their commitment to preserving this legacy and for creating a platform for intellectual discourse and reform-driven action. As we deliberate today, may our conversations ignite change, strengthen institutions, and reaffirm our collective resolve to defend all of the ideals Chief CO ANAH stood for. Thank you, and may his legacy endure. Thank you very much.
Jade is a very powerful woman. She's a woman of both force and fire. Currently the only female secretary in the FCT area. She inspires us all. Those of us who have daughters and are hopeful that opportunities will not pass them at all. Jade really share that hope with us. Thank you so much, Jade, for that. Next, for goodwill message, allow me to invite Martins Atojoku. He's a team lead for LACRI. LACRI is the Legal Assistance and Citizens' Rights Initiative. Please make him welcome, Martins Atojoku.
Thank you so much. It's a rare privilege for me to stand before you all. My name is Martin Atojoko. I congratulate the ANAH Center for this wonderful occasion. In fact, Ada, the major organizer of this program, is part and parcel of our team at the Legal Assistance and Citizens' Rights Initiative, and she has also contributed so well to us. My greatest takeaway from this colloquium today will be for all of us to live with this word, which has always been said, that the man in all dies if we all sit and watch in the face of tyranny. So let us open our mind today and seek to listen to the speakers who are about to present their various speeches to us today. I assure you, I promise you, we'll all be glad we took our time to be here. Thank you so much, everyone, for being here.
The speakers are going to come up here will understand the challenge that I have. There are lights pointed at me that are quite blinding. And that's the only explanation I will give now for meeting my boss, Madaki Ahmed, who I saw when I stepped out there. My boss, can I invite you for your goodwill message, please? Madaki Ahmed. Make him welcome. A very senior lawyer, for that matter, and a leader at the bar. He deserves that and even more. I will continue clapping.
Yeah, thank you very much, the MC. This is actually quite impromptu for me, but as lawyers, we have to expect to be called up whenever we're called up, to say what we have to say. Let me first start by congratulating those who have put this together. One of the best things we can do for our parents when they are passed on as great people is to ensure that their legacy is not allowed to just fritter away. And as professionals, especially as lawyers, one of the things we must keep doing is to ensure that the legends of this profession are not allowed to just disappear into oblivion, even when they are no longer with us. It's when we celebrate the best among us that, the best of this profession is revealed. I'm happy to be here today to deliver a short goodwill message at this very august occasion, celebrating a true legend of this profession, CEO ANAH SAN. I know that the speakers are going to do a lot of justice to the topic of today. We have the ever erudite Professor Chidi Odinkalu and Aisha Yusufu. And I know that, we are just going to be held spellbound, while the discussions are going on. As an in-law of the Igbo Kingdom, and the Igbo nation generally, in the whole world, I've been married to an Igbo woman now for 26 years. So I can almost claim that I'm an Igbo man, I am happy to be here today to celebrate a great Igbo man, a great Nigerian, a great Pan-Africanist. And all I can say is that, we are going to have a good time. And I'm not going anywhere until the very last person leaves here. Thank you very much. God bless you.
That's a very firm declaration. I used to work as part of a team where the leader of the team, anytime he makes an omission and you confront him with it, he will tell you, I'm unaware. And he copied that phrase from a former president of this country who would say, I'm unaware, I assure you. So whenever I step down from this podium and go away, I see more people that are deserving of acknowledgement, and they need to come and give us their goodwill messages. So I'm unaware that they were here, and I assure you that I will do everything I can to invite them here. My boss, Steve Emeleze, the chair of the Abuja branch of the Nigerian Bar Association, is here. I apologize, forgive me, and please, we invite you for your goodwill message.
Thank you very much. Permit me for one time so that I also don't skip anybody to simply adopt the already established protocol. A lot of goodwill messages. I cannot adopt them as mine, but indeed I must say that our sister Adeze is highly encouraged and appreciated for this effort. In this part of the globe, people tend to forget, their parents and forebears quite so easily. To set up a colloquium of this nature, which I understand this is the 4th edition, is quite commendable. It affords the opportunity, for not just for those who read late CEO ANAH SAN's book, but he keeps living not just in our heart, but in reality. I'll stop there because today is a lecture day. I can see Prof, we are about taking so much of his time, and some of us are eager to hear from him because we always appreciate when we read his piece or hear from him. I'd like to thank all of you who have made out time to be here, despite your busy schedule. It's not easy to be invited. I always tell people when you cook, you set a feast and you cook for people to come. If they do not come, the food is wasted. So if you were not here, this would not have been a success. So I thank all of you who are patiently waiting, not just to learn, but to be a part of this colloquium. I thank you so much, and I also thank the organizers for finding me worthy of being here, not just because I'm the chairman of the MBA, and giving me the opportunity to appreciate you. Thank you so much.
Thank you very much. Many of you wonder why I keep calling Paul Harris my boss. The reason is he's actually my boss. I was on the PDP presidential legal team at the last election petition tribunal, and it was our senior. So when I was also leading some House of Reps petition at the election tribunal, sometimes we will not have any questions to ask, and they cancel from the other side. We just tell us, just adopt anything we are doing, just adopt. It was always worrisome for me, but let me encourage the goodwill speakers that are coming to adopt the briefness of Steve Emeleze's message, and also speak in like manner, especially because I'm going to be calling another of my inspiration, Rachel Adejo Andrew, the former president of FIDA. She is formidable, she is strong. Let's make her welcome.
A very good afternoon, my Lord, the learned senior advocates of Nigeria here present, distinguished ladies and gentlemen. MC, thank you for promoting me, but I'm not the president of FIDA. I was chairperson FIDA Abuja branch, and at the moment, by the grace of God, I'm the national secretary of FIDA Nigeria. It gives me great pleasure to be here this afternoon on behalf of the FIDA family, FIDA Nigeria, and by extension, FIDA Abuja branch. I'm not sure I've seen the chairperson here, so I can speak for the FIDA family. We identify with Adeze, who is our member. We congratulate her for keeping the legacy of her father on. You know, like the Yorubas will say that it's good to have children, but it's more important to have children who see your vision and who will carry your vision even after you have passed. And I think Adeze qualifies for such a child. This I understand, just like my chairperson Emeleze said, this is the 4th edition. And it's no mean feat to organize a colloquium. So congratulations on behalf of the FIDA family. We trust that today's discourse will be both impactful and insightful. In fact, when I saw the list of the discussants today, I was eager to come and see how they are going to impact me. So I can only say to us that let's sit down, relax, listen, and participate when it becomes necessary. So I congratulate you, and on her behalf, I thank everyone who is here this afternoon. I wish you all very, very fruitful time this afternoon. Thank you.
I have an excuse for that error. 2 weeks ago, the chairman of my branch, the MBA Buhari branch in Buhari, appointed me the sole administrator for the Women Forum for 6 months. So because of that, that's why I felt as if, you know, sole administrators don't do things right. So I omitted that, and I apologize to you, my dear sister, Rachel Adejo Andrew, and your title is fully recognized. With that said, let me take a moment to recognize someone whose work has been the bedrock of hope in this country. She has helped and validated a lot of dreams by the work she's been doing for months and years, as a matter of fact. Ladies and gentlemen, help behind bars has been a fundamental pillar in advancing the cause of human rights for those who are indeed behind bars. Funke Adeoye has been a driver and a champion of that cause, and she has been a formidable leader in this country in the advancement of human rights. Let me invite her to give a goodwill message, my sister and friend, Funke Adeoye. Please make her welcome. She thought I would not call her. I'm sorry, Funke, but your work speaks for you.
Good afternoon, my learned seniors, the Honorable Justice, and distinguished ladies and gentlemen. So I didn't see this coming at all, but I'm grateful for the opportunity to be here and to be part of this very insightful conversation. The CEO ANAH Center has been working on this colloquium for the past 4 years, and I think that it's important that we have conversations around the rule of law in the country, and we already have distinguished ladies and gentlemen who will be speaking on the topic from from Professor Odinkalu, who is a very senior friend of mine, and to everyone else that will be speaking. We look forward to a very engaging conversation. I am actually looking forward to a very engaging conversation, and I would say a very big congratulations to the CEO ANAH Center for this wonderful colloquium. Thank you.
As we progress, we'll be recognizing more people that are here. Well, let me now invite the keynote speaker to present his speech on the topic of this colloquium. Ladies and gentlemen, please make welcome Professor Chidi Anselm Odinkalu.
Learned colleagues, dignitaries, ladies and gentlemen, fasten your seatbelts, because what you're about to witness is not just a keynote, it is a call in robes. An intellectual thunderstorm is about to erupt on this stage. Coming to the podium with a legacy forged in the crucible of justice. He's battled brutality, dismantled oppression, and faced impunity head-on. The former chairman of Nigeria's National Human Rights Commission, a pioneer of African justice. A reckoning in he doesn't just speak truth to power, he makes power listen. Make some noise, rise to your feet, and welcome the indomitable, unstoppable, unflinching force of legal clarity and moral courage. Professor Chidi Anselm Odinkalu.
Sorry, good morning. Sorry, please, this is embarrassing. Adeze, I will retaliate. I can promise you that. But thank you ever so much for the opportunity to join this morning. And even more, for the opportunity to be in the company of so many people who are committed to the administration of justice in the country. I want to abide by existing podium protocols and recognitions, but pay special tribute to the Honorable Justice Alaba Ajilaye. And not just because he's here. I hope he gets to write his memoirs. I'll just say two things on Justice Ajilaye. The first is at a time when a lot of scandals about age of senior judicial officers are at the bubbling up beneath the surface, it's good to see a judge retire and have another life. It says that he went to the bench with his true age. And in this day and age, you cannot take that for granted. But the second thing is also that greatness at the bench is not determined by how high up you go. There are great trial judges. There are great appellate judges. There are great chief judges. There are also scandalized and scandalous chief justices. And I don't at all flatter the Honorable Justice Alaba Ajilaye if I say he has been a great, great, great trial judge. There is no other judge in the history of this country that has saved two chief judges. In Kogi State, in 2008, when the Honorable Chief Judge Umar Eri was going to be fired, they wanted to get rid of him because he was not willing to carry money and go and bribe Election Petition Tribunal on behalf of the then ruling PDP. The case went before a judge who was 2 years as a High Court judge, the Honorable Justice Alaba Ajilaye. He saved the career of his chief. And 12 years later, he also saved the career of the late Honorable Justice Ajana. I cannot imagine what stresses and pressures you faced, sir. But I'm glad to see you still trucking, and I hope you are able to tell that story someday. Thank you, sir. And for those who wonder why I say this, some of you may have seen the rejoinders by two sons of former senior judges in Nigeria. The son of former Chief Justice of Nigeria, Shode Indesho, and the son of a former High Court judge in Lagos State, the Honorable Justice Jinodu. And when you read those rejoinders, they were rejoining to me, you will see that you can be Chief Justice, but a High Court judge can be greater than you. That is what comes clearly from those two stories. Justice Jinodu retired as a High Court judge of Lagos State, but he ended up the greater figure. And talking about figures, I'm very glad to be here. And I told Adeze, I'll tell a story I told you. I came here for one reason. And it's not a reason most people will, people want to hear about judiciary, independence of the judiciary. That's not why I came here. I came here because a daughter is honoring her father. You know, as Nigerians, we want to give birth to sons. And when we give birth to a son, in my part of the world, for instance, we call him what? Amechina. He will do what? He will ensure that our name is not lost. But who told you that your son will guarantee that your name is not lost? Cyprian Okafana did marry. We remember him today because he had a daughter. As we worry about the judiciary, and rightfully so, please, if you're here, invest in your daughters. Train your daughters. Give them confidence. Reassure them. Make them feel like they are truly, truly equal with their brothers. Because the person who will continue your legacy tomorrow may be that daughter. In all likelihood, the person who will guarantee your legacy will be that daughter. Boys will be stolen by the babes. Nobody ever steals the heart of a daughter from the being of the father. Ada, Dalurine, thank you. And if CO ANAH Senior Advocate had been alive today, he would have turned 90 in September. This is about independence of the judiciary, but the man was multidimensional. He was more than a lawyer. He was a banker. He was a sportsman. He was a writer, as you've heard from my brother, Paul Harris, a future president of the Nigerian Bar. He was a restaurateur. Of course, he was a father. And we know he was a lawyer. He was a bar leader. Of course, a senior advocate. He was a Christian, a man of faith. He was an egalitarian advocate. Something that we've not heard so much about, and that I hope you write it someday. He was a lover. He loved Wanya Saba very much. And he loved with all his heart. He was very tender. And in the midst, my leader, Ezenwa, Ekenem, when in the midst of what we've got today, we no longer talk about love. But love is a very important thing. And I hope for everyone here, you get to experience love in your lifetimes. In 2006, CEO and myself, we both worked on the successful campaign of Olisa Bakoba for the presidency of the Nigerian Bar. CEO, of course, was Olisa's mate in the Nigerian Law School set of 1978. A lot older than Olisa, but they were mates in the law school nevertheless. On the night of the count, he was actually Olisa's polling agent. And he did that job with tremendous panache and humor. The man had a wicked sense of acid humor. But, you know, he made us all laugh amidst the stress of counting. And it wasn't quite clear at some point that night whether Olisa had won or lost. But, you know, he kept us going with laughter And he kept us believing whatever happened, there'll be a tomorrow. Even if we lost, we will all still be friends working out of there. And I wish that we could still bring that sense of humor to our elections. And the man just had immense polish. That's all I remember him for. And I can't say I knew him well, but he had immense polish. And I'm not surprised that he's given birth to a titan of a daughter in Adeze. And it's really that package of being, the egalitarianism that brings us here. You know, when people hear we are coming to speak about independence of the judiciary, and they think my sister Aisha and I are here, they say, oh, those activists, they like abusing judges. So let me get that out of the way. I have 2 children that I know of. You know, my brother, the Okaleya, Madakiame, has just announced here that he is genitally Igbo. So from the waist down, he is Igbo. And from the waist up, he is from somewhere else. But we will accept any part of his anatomy for this purpose. Now, I have 2 children. My son, I give a lot of grief. And he's always asking me, Dad, but why are you not treating my sister this way? And I say, well, you're my son. And one of those days, he really was very angry with me. And he let me know that he was angry with me. So I calmed down. The following morning, I walked into his room and sat down on his bed, saying, Nkem Delim, that's his name. Nkem Delim. You know, there is something worse than giving you grief. He says, what's that? It is ignoring you. Giving you grief should not worry you. But the day I am so pissed, I ignore you, that should worry you. The day we all become so pissed, we start ignoring the judiciary. That is what should worry us. The fact anyone who cares enough to give you grief shows you love and shows you respect. Anyone who cares enough to worry about the integrity of the judiciary is showing an act of respect, profound love, and care. And my hope is we don't have to be all of the country or all of the legal profession, but there are enough of us in this hall today to show we care about our judiciary. That's all that matters. Let me also say this and get it out of the way quickly. There are lots of very hard-working judges in this country. A lot of them. They are working under very difficult circumstances. And many of them, many conscientious judges in Nigeria, suffer tribulation for being conscientious. Today, your orderly will be withdrawn because you gave an order that somebody didn't want you to give. The following day, you're moved to a court that is leaking because they want you to suffer for an order you have given. The day after, they send you to a post, a duty post that is really terrible because you have done your work conscientiously. But we are not just before courts of law. We are also before courts of the Lord. And we are before courts of posterity. And we are before courts of public opinion. And my experience is that all of those, what goes around sooner or later comes around. And all of those temporary setbacks, in many cases, prove those of them who are really doing things right. But precisely for the sake of those judges who are doing things right, we've got to continue to stay on the case of judicial independence. I stopped counting death threats on this matter of judicial independence long ago. At a point, I was actually recording. After I passed 2,000, I stopped recording because I was still alive. I hadn't died. Death threats do not kill. If you listen to them too much, you will not do anything. But in any case, I'm over 50, I'm old enough to die. And at some point, you've got to worry less about your mortality and worry more about the kind of society we live in and about our public commons. And the state of our public commons should worry all of us as Nigerians. And so, that is really what I want to call attention to. And I must pause because my criminal law teacher just walked in, Professor Ernest Ojukwu, Senior Advocate of Nigeria. He taught me criminal law in 1985, and he's still looking more sexy than me. Yes, so. So I'll be very brief in what I'm about to say, and it's a bit of an anticlimax. Why that is so, I hope you will understand. I've had a book-length entry on the issue of independence of the judiciary and human rights in Nigeria. The book is just about to hit the bookshops. And I have had my say, at least for this round. What I therefore want to do is very simple. Introduce some theoretical aspects of this subject matter and allow the conversation to flow, because we've got two perspectives I think that are important. The perspective of a retired judge who saw it from the inside, and the perspective of a citizen, an active citizen, who sees it as the consumer. And those two perspectives matter and are complementary. Why is that so? Because independence of the judiciary is too important to be left to judges and lawyers alone. And I had to leave the profession and discover my civic dimension in order to be able to address the subject matter properly. Because as lawyers, we actually cannot deal with independence of the judiciary. And let me try and explain what I mean. As lawyers, we are self-interested in the subject matter. We are not independent. Our clients rely on us to articulate their cases. We are going before the same judges. And if a judge doesn't like you, your case is done, even before you say, "May it please my Lord." And therefore, when we come at this subject matter with a case in court, we come at it with trepidation and not with fearlessness. Why do I say not with fearlessness? You need a bit of history. We need to unwind a bit. You know, first of all, as for those of us who are lawyers here, we are taught that at independence, actually, the story across the board in the Commonwealth is that at independence, the British bequeathed to us independent institutions, particularly an independent civil service and an independent judiciary. I lie? That's what we inherited. And if you read, there's a lot of adulatory material about how the British gave us independent institutions, especially independent judiciary and rule of law. That is a lie. That is absolute bunkum. But this is what we are taught in the law school. From university, you start learning it from legal system, administrative law, constitutional law. By the time you become a lawyer, it becomes the truth. It's a lie. Just do a little mental effort. Colonialism did not have independent institutions. How could it bequeath what it could not have? Colonialism actually was built on the idea of your inferiority, my inferiority, the inferiority of our race. It was built also on the idea that judges served at the discretion of the colonial office. This is not my view. There is the jurisprudence to prove it. If you doubt it, read Terrell and Colonial Office, which is a 1953 decision of the King's Bench Division in London. It's very clear. There were no independent judges in colonies. And therefore, when independence came, there were no independent judges. That's the first thing. Our learning of law was built on a lie. But it didn't end there. It was also built on another fiction. That all of our institutions were invented by white people. So we were mentally incapable people. That is where this whole problem starts. So, in legal system, we are introduced to what? Received laws. Our laws start, and there are young law students here, Abi. I see. So listen to me and listen good. The rest are gone, no. It's me and you. Now listen. Because the concept is the concept of terra nullius, lex nullius, which was inscribed in law by the Privy Council, the Judicial Committee of the Privy Council, in 1918, June 1918, in the decision in Southern Rhodesia. You can take the citation down. 1919, appeal cases, page 212. You can actually read from page 231 to about 237. That is where our race is written off as a matter of law. And we were told that nothing existed in Africa before the white people came. Some of you would have learned while you were in school that Mungo Park discovered where? River Niger. David Livingstone discovered what? Livingstone Falls. De Brazza discovered where? The source of the Congo. That is why the capital of Congo, Brazzaville, is called what? Brazzaville, because it is named after De Brazza. All right? Now, actually, because of that, all of our institutions are written off. And what happens? The basis of our law is common law, doctrines of equity, statutes of general application in force in England on the 1st of January 1900. Now, your average teacher of legal system will tell you that and require you to recite that. It is a crime against yourself. How can you be bound by laws that were enforced in England when Queen Victoria was still ruling and you think you're normal? And your teachers don't even challenge you as an act of intellectual and civic curiosity to say this is not right. Because we were told that we inherited independent institutions, we did not train our students to be active citizens. That is why I am so pleased that Aisha is here. We did not train our students to be imaginative, to reimagine the kind of country that we are going to live in. And that is why our legal profession subverts citizens. How can you live with laws that England has rejected? And you're being taught that that is what should govern your children, not just you. And if you don't say that, you would have failed. And if you write your undergraduate long essay and criticize that, the teacher will fail you too. And you think we're in a normal place. We are not. That is why I invite every one of you to rebel against that. Get your certificate, but refuse to be bound by that. Because it is important to reimagine this space. Nobody gives you independent institutions. Independent institutions are fought for because nobody wants an independent institution to police them. And I'll give you the stories. I'll go and sit down. You can read what I've written. Why do I say we never had an independent judiciary? You don't have to go far. We started with After Nigeria became federal in 1951, at the London-Lagos Constitutional Conference 1953-54, we decided one of the issues was what? Decentralization of the judiciary. At the time, John Verity was the Chief Justice of Nigeria. Verity was a white man, and he feared that decentralization would compromise independence of the judiciary. But the politicians wanted decentralization. They did not want judges appointed by someone to be overseeing what they were doing. So the politicians in Lagos in 1954 voted for decentralization. John Verity resigned as a result. He resigned as Chief Justice as a result of that. Quickly, Ghana became independent in 1957. Okai Kwashi Aidu, who became the senior judge, became exiled very quickly after that because he disagreed with Nkrumah of trying to assert independence of the judiciary. Nkrumah exiled Okai Kwashi Aidu. Where did Kwashi Aidu end up in? He ended up in Western Nigeria, where he became Chief Justice of Western Region, because that's what they were called then, Chief Justice. Kwashi Aidu became Chief Justice of Western Nigeria in 1960. Shortly thereafter, the crisis in Western Region broke out. And every one of us remembers that case if you've gone to law school. That's the case of what? Adegbenro and Akintola. Now, Akintola, at that point, had Okai Kwashi Aidu as his Chief Justice. And he was Kwashi Aidu's patron. Kwashi Aidu, Akintola filed the case after Obadesoji Aderemi had tried to sack him, seeking to assert his position as Premier of the Western Region. The case went before the Chief Justice, Kwashi Aidu. Kwashi Aidu decided to duck the bullet and state a case for the Supreme Court. Akintola, meanwhile, had expected Kwashi Aidu, given their personal relationship, to give him victory at the lower court. So he would have that in the pocket. If Adegbero wanted to appeal, he would appeal. When Kwashi Aidu stated the case to the Supreme Court, Akintola lost political leverage in the shenanigans. And that was the end of Kwashi Aidu as Chief Justice of Western Region. He suffered a second exile shortly thereafter, leaving from Western Region, and he ended up in East Africa as the president of the East African Court of Appeal, where he died in 1966. Now, what happened? That case went from Supreme Court, or Federal Supreme Court as it was called then, to the Privy Council, where the NPC and NNDP of Akintola lost. They lost the case. But they legislated the judgment out of being. What happened? Number one, Nigeria became a republic at the instance of the NPC, Northern People's Congress, NCNC, NNDP coalition. Number two, as a result of that, the Privy Council was abolished as a final court of appeal, together with all its decisions. Number three, the Federal Judicial Service Commission was abolished. That's the one nobody will tell you. As a result of that case, they abolished the Federal Judicial Service Commission. It was only reinstated in 1979. Now, what then transpired? We then started hurtling. But if you do not understand what happened with Adegbero and Akintola, you will not understand how Lakanmi was overruled by federal military government supremacy and enforcement of powers decree number 28 of 1970, because it started with what happened in 1963. And it was the same person who lawyered the two, Taslim Elias. He was Attorney General in 1963. He lawyered the aftermath of Adegbero and Akintola. He also lawyered the aftermath of Lakanmi. And this is why I no longer teach doctrine. I teach history. Because if you don't understand the history, doctrine means nothing to you. Doctrine is a way to make us, inoculate us against the consequences of knowing what has happened to us. I no longer teach doctrine as law. I teach law and development. I teach international human rights law. I teach constitutional law. But I don't teach doctrine anymore. I tell the kids, this is the story of what happened. Reach your own conclusions. This is what the court said. These were the characters who were there. This is what they did. Unless you do that, you are wasting children as lawyers. Now, what then transpired? After Adegbero and Akintola happened, we abolished Federal Judicial Service Commission. We replaced it with the Advisory Judicial Committee. The AJC then did what? When Chief Justice Ademola was retiring in 1972, Gowon was happy to transform his Attorney General to become his Chief Justice. 3 years later, Godwin Dabo had used an affidavit to get rid of a minister. Who was that? Joseph Sarwantaka. Yes? And then he was going after the governor of then Benue Plateau State, who was Gowon's in-law, Joseph Gomwok. Gowon said, no, that will not happen. He put a call to the Chief Justice. The Chief Justice called an emergency meeting of the Advisory Judicial Committee. They abolished affidavits in Nigeria. But the AJC did not have power to abolish affidavits. Think about it. They issued an instruction through the Chief Registrar of the Supreme Court abolishing affidavits in Nigeria. That was how, shortly after that, the coup happened, and Murtala Mohammed became president. One of his first acts was what? Guillotine Taslim Elias. He was gone as Chief Justice. And then they exiled him to The Hague as a judge of the International Court of Justice. And then we hired a non-Nigerian as Chief Justice, Danley Alexander. We gave him a contract for 3 years. He was going to be Chief Justice from 1975 to 1978. But we were doing presidential elections in 1979. So what happened? They extended his tenure by 1 year, from 78 to 79. We did elections in August 1979. Awolowo, or the petitions, election petitions were supposed to be filed by 22nd of August 1979. On 21st of August 1979, two things happened. In the morning, Awolowo filed his petition at the Election Petition Tribunal. In the afternoon, Obasanjo called Fatai Williams and told him he would become the Chief Justice. The same day. And the first decision of the new Chief Justice was to decide on Awolowo's election petition of 1979. The judgment came down 4 days before the transfer of power. 6 days before the transfer of power, Fatai Williams called Obasanjo and told him, Tazarche. He told him, carry go, the judgment will be in your favor. Judgment started leaking long ago. It wasn't today, it started leaking. Fatai Williams gave Obasanjo foreknowledge of the decision of the Supreme Court in 1979, breaching conference confidentiality in judicial decision making. So, why is that relevant? When the presidential election petition tribunal was about on the day that, no, the day before they were to announce their decision in 2023, the current president flew off to India. If I were to be a betting person, I would tell you he had already been told what the decision would be. A president who does not know what the outcome would be, would not have gone off to G7 summit or G20 summit the way he did. The reason I tell this story is basically this. We've got to invest in understanding where the rain started beating us. In Nigeria, independence of the judiciary is not something that is in outer space. Independence of the judiciary is a human right. I don't know whether anybody realizes that. Section 36(1) of the Constitution says what? That every person is entitled to fair trial before a court constituted in such a manner as to guarantee its independence and impartiality. Have I misquoted it? That means judicial independence is a human right. And whenever, therefore, judicial independence is imperiled, human rights are violated. And the Constitution gives us a right where human rights are in peril to go to court or to seek remedies. If they are frustrated, you do what? You cannot flog a child and ask the child not to cry. This is the point about, this is why we must fight for judicial independence. It is a fundamental right. Not even judges can take it away. And you heard the former vice president in Yenagoa complaining that it is now beyond peril. Everybody is complaining. So who will bail the cat? It is us. We cannot outsource it. And this is not just a matter for the, I'm not just going to say this is confined to section 36(1) of the Constitution, because it's also in the African Charter on Human and People's Rights, Article 26, right? It is there in the African Charter on Democracy, Elections and Governance, Article 17. So that's as a human right, judicial independence. And in my remarks, which are brief enough, in my written remarks, I've dealt with the meaning of judicial independence, why it's important. But let me end on this note. Because judicial independence is not negotiable in a free country or a civilized country. There are 3 monopolies that every state enjoys. Number 1 is the monopoly of legitimate taxation, presumptively. The second is a monopoly of legitimate dispute resolution. And the third is a monopoly of the instrumentality of legitimate violence. Where a state gives up its monopoly of legitimate dispute resolution, it creates a zone of contest over its presumptive control of the monopoly of legitimate violence. That is why vigilantes are everywhere. I don't know whether you get what I'm saying. If people cannot get their disputes resolved fairly and properly and do not believe they can, what happens? They resort to vigilantes. Over the past 4 days, I've been around, God knows, every part of this. I've been to 5 geopolitical zones in 4 days. And I've been meeting with lawyers and judges and all of that. One thing is very clear. A lot of people are taking their cases from courts and giving them to vigilantes. Southeast, Southwest, South-South, Egbesu boys are deciding cases. ESN boys are deciding cases. Militias are deciding cases. Litigants are taking their cases and giving to these militias to decide by ordeal. Lawyers are losing briefs. Judges are being casualized. Magistrates are afraid. The police are running. Why? We also have to, as lawyers, we also have part of the responsibility, because we have ceded what we should not cede. I was with a bunch of judges in Warri yesterday, and I told them, they were surprised. They didn't know that I was a person of faith to begin with. So when I told them that I actually pray for every judge, they nearly dropped from their chairs. They were laughing. I said, I do. Because I've seen the toll that being a judge takes on those who do the job. Being a judge is the most dreadful thing anyone can be asked to do. It is the most impossible job. And I swear, I pray for every judge, including Olukayode Ariwola, for whom, as you well know, and I will confess, I don't have any kind thing to say. But I pray for him. I'm not God. It's up to God to decide the things that are within God's remit. But I pray for absolutely every judge. And I wish judges well. And I wish judges would do right. But I also wish lawyers well. And in particular, senior lawyers. Being a senior lawyer comes with burdens. And I see senior lawyers at the front here. Being a senior lawyer is not easy. It means you become an intercessor. Sometimes you've got to do things, not because they will bring you money, but because they will bring you things that money cannot pay for. And I was telling somebody yesterday about my late Egbon, Kami Ishola Osobu. Peoples. And as a lawyer who was 2-3 years old at the bar, I would have cases representing, we're representing the leadership of the National Association of Nigerian Students who were detained. And I'll go to Kami in the afternoon, in Yaba. I'll go to Kami. Kami will be in between 3-4 women. Haslam! I'm quoting, I love the man. Haslam. Women are the lubricants of struggle. I say, Oga, that's not why I'm here. But he's so rest. And I tell Kami my problem. He said, no problem. Which judge is it? Which court is the case before? I'll tell him. He said, I'll be there. The following morning, the court starts sitting. 9 o'clock, I'm fretting. I don't know what to do. Kami has not arrived. 10 o'clock, Kami is not there. We are before Justice Christopher Shegu, who was very cantankerous. 10:30, 10:45, somebody starts shuffling. He's wearing, this person comes in, black trouser, white shirt, milk bib, blue jacket, brown sandals. Kami was a life bencher. He goes and waddles into the front seat. And the case finishes. Kami puts his brown sandals on top of the chair. My lord, people's here. The judge looks up. The judge and Kami were in the same set at the bar. He couldn't do anything. My lord, people's here. I'm interested in case number 14. Mr. Commissioner Shobu, why are you late to my court? My lord, do you want us to tell that story today? Anyway, my lord, I'm interested in case number 14. They call it up. My lord, people. And with me is my colleague, my learned colleague, Chidi Odinkalo, and he will present the case. He jumped the queue for me. 1, 2, 3. That is how we got Bamidele Aturu released, Abdul Mahmoud Aminu released. We got all of them released because Kami Ishola Osobu showed up in court in a state of semi-inebriation to get us ahead of the queue. He was that committed despite any and every other thing. And this is the intercession I'm talking about. Because there are things that will not happen to you. And I invite those of us who are senior, and it's not just, senior advocate of Nigeria is senior, obviously. But that is not the limit to senior. Life ventures are senior. I've been a lawyer since 1988. Don't mind that I can't afford a decent pair of shoes. But it is important that our seniors begin to intercede and do those difficult things and have those difficult conversations without which our profession cannot go forward. It will then be left to those of us who are armed with sand and stones to be doing the things that seniors will not do, because we need our seniors to continue to look responsible. But there are things that seniors cannot do which have to be done if we are going to turn around our profession. We will do that is necessary without giving anybody gratuitous abuse. Let's be clear. Fighting for a better judiciary is not about abusing anybody. Nobody should be abused. We have to respect people. But we also have to respect facts. And that is why I don't write in adjectives. I will tell stories about what happened, and I will tell you this is where the source is. And when you read the selectorate, which is giving me a lot of grief now, a lot of people are calling to abuse me on a book they have not read. It has over 750 footnotes, sourced to original material from the National Judicial Council, reports of NJC disciplinary committees. When you read these things, you will weep for our profession. So that's the note on which I end. For the young people here, because when you hear this, you say, oh, there's no hope. I would not be doing what I do if I did not have hope. I sell hope, not renewed hope. Because my hope does not need renewal. My hope is original. And I want you to be hopeful about your country. I ask you to be hopeful about your profession, the profession or vocation that you're choosing to go into. You're going to meet obstacles, but those obstacles have always been there. That's why I started the story from 1954. And if you don't overcome obstacles, you will not establish yourself. When we were in law school in 1987, the then director of public prosecutions in Lagos, Abiodun Nureini Kensington, came to address us. And he says, my people, welcome to the legal profession. It is pursue me, I pursue you. Ladies and gentlemen, independence of the judiciary is what? Pursue me, I pursue you. Thank you.
Thank you very much, Prof. His book. Thank you very much, Prof. That was very, very powerful and insightful. And he really spoke truth to power. When he was speaking, I remembered an incident that happened to me myself about 8 years ago when I was representing a client who had somebody that had taken some money from him. And he was struggling to get the money back. And he had come to our law firm for us to help with that process. And we gave him all the assurances that we're going to retrieve that money back. We had had a very previous unpleasant experience with the judiciary that took such an awful amount of time with him navigating through it and getting his money back. So in the process, he called us to his office. We gave him our charges, our bills, all the assurances that we'll do our very best, told him of the processes. And then he told us that the last case he did, he spent almost 7 years in court trying to retrieve his money from somebody. And we asked for us to do a meeting with the person who was owing him the money. And we did that meeting. And the man came very bold and telling him, there's nothing you can do. I won't pay you back that money. Do your worst. So he turned to me and he said, you see now, he's not even scared of the courts because you people can't do anything. But no problem. Let's meet tomorrow. So went back to our law firm. The next day I called him to ask if he was still coming to the law firm for us to commence the process of civil action to get his money back. And he told me, I'm on my way to Calabar. So I'm like, why did you travel when we had the meeting? He said, I'm going to go and find another solution. Because this court own, it doesn't look like it will work for me. So I'm like, okay, I will just leave him. About a week later, we got a bank alert that he had paid us for some of the legal work we had done. I'm like, okay, why are you paying us? We've not even started work. And he said, that case is concluded, though. The man has paid me. So I'm like, how did he pay you, sir? He said he went to a traditional means and the gods visited the man to pay him the money. And the man immediately paid him the money. So when Prof was talking about that point, that was very striking for me. Thank you, Prof, for that insight. Next up, I'm going to be inviting my Lord, the Honorable Justice Adile, to give us his speech.
Ladies and gentlemen, distinguished members of the bench and the bar, guests and custodians of justice. Today, we are graced by the presence of a jurist whose name commands reverence, not by titles alone, but by the legacy he has built in the courtroom, in the classroom, and across the legal terrain of our nation. A man of rare distinction. He is not merely a retired judge of the High Court of Kogi State. He is a professor of law, a pioneering mind in the field of electronic evidence, and an unblemished defender of judicial ethos. Appointed to the bench in 2005 and bowed out with honor in 2023. His judgments were not only legal pronouncements, they were reflections of principle, beacons of moral clarity, and anchors of constitutional fidelity. His magnum opus, Electronic Evidence, Revised Edition 2019, is now the reference text for courts, advocates, and scholars alike. And his works continue to shape discourse in Nigeria and beyond. As a consultant to national and international bodies, from the National Judicial Institute to GIABA, AGA Africa, NILES, and the Rule of Law Development Foundation, he remains a vital voice in shaping judicial capacity and legal modernization. Tonight, we receive not just a speaker, but a teacher of judges, a mentor to lawyers, a living archive of legal excellence. Please welcome with the honor he so richly deserves, a scholar, a judge, a leader, the distinguished Honorable Justice, Professor Alaba Omolaja Ajile, PhD, FICMC, retired.
Senior advocates of Nigeria here in the House, distinguished guest speakers, let me especially acknowledge Professor Ernest Ojukwu. If Professor Ojukwu actually taught Professor Chidi Odinkalu, it means I too could easily have taught him, because Professor Ojukwu and I, we were classmates. We were called to the bar in 1984. So it's a great honor having you here, Senior Learned Silk. Well, after this very thought-provoking speech by Professor Chidi Odinkalu, I wonder what else will I say, except for the fact that I am looking at the matter from another background. He spoke like a historian. I am going to speak like, well, not a judge now, an ex-judge. And I want to especially appreciate him for the very kind words he said about me. I will say here that I really feel highly flattered by all that he said. Anyway, be that as it may, distinguished guests present here, I will go straight to my paper. And the first is showing appreciation, which I had briefly done when I was invited up here, except to add here that we have heard so much about the late ANAH SAN, CEO ANAH SAN, a distinguished author, and a great scholar, a man who was a paragon of legal excellence. From what I read about him, he can easily be described as a distinguished personality and a man of integrity with an unrelenting passion for justice. And so, I will only add here again that may his legacy continue to inspire and motivate us to strive for excellence. And I am confident that the discussion we are already having and the reflections we are going to engage in over the course of this colloquium will be a fitting tribute to his enduring legacy. Thank you again, the organizers of this program. I have a preamble to my paper here. The topic that has been assigned to me is From Pressures to Principles, the judge as the backbone of human rights enforcement. I try to understand that topic, and my understanding of it is that it only attempts to underscore the role of judges in upholding human rights in cases where they, that is the judges, are expected to provide remedies for victims of abuse of fundamental human rights. The topic also underscores the point that for judges to effectively enforce human rights, they must maintain independence and impartiality. They must demonstrate character and courage to make decisions based solely on the law without external pressure or biases. I proceed to explain the notion of fundamental human rights here, which Professor Odinkalu had ably treated. But all the same, we have to acknowledge that these rights that we are talking about, they are rights that are inherent in man, rights that are universal, rights that are inalienable, rights that every man possesses simply by virtue of the fact that he is a human being. I mentioned here that nobody, no power, no authority confers such rights on anybody. They are not donated by the government and therefore cannot be capriciously taken away by any government. I mentioned some of them here, right to life, right to liberty, fair hearing, and so on and so forth. These rights, as we know, they are very essential for human dignity, for freedom, and for well-being. Therefore, I make a point here that whenever a case of enforcement of human rights comes before a judge for adjudication, something should speak to his conscience, the conscience of the judge, that it is not a matter that should be treated with levity. Judges must provide guidance on human rights issues by making pronouncements that will help to prevent abuse. So I am pleased, I'm glad to be here to speak about pressure of judges, the pressure that judges face in their work. I am also pleased that as a retired judge, I can now share my thoughts freely. Professor Dinkalu has challenged me already, and already I'm saying it here. I am happy that as a retired judge, I can speak my mind freely without concern for repercussion from the National Judicial Council. I am no more under their jurisdiction. So, drawing from my nearly 2 decades of experience on the High Court bench, I can now provide practical insights rather than hypothetical or academic scenarios. That is what I have come to do here. I have no lecture to deliver. I have no theory to propound. I have no pontification to make, but I have experiences to share. And the experiences I will share at the time that you will ordinarily find in memos. Professor Dinka also challenged me that I expect that I should have my memo. I mentioned it here that I thank the organizers of this program for inadvertently setting the stage for me to begin to write my memos. Basically, judges have mandate, and I want to make it as a threshold point that judges, in upholding their sacred duty to administer, of course, that is their basic mandate is to administer justice. So in doing this, they are required to adhere to ethical principles outlined in the Code of Conduct of Judicial Officers. And again, upon appointment, judges swear to an oath to impartially dispense justice. Justice to all individuals, unaffected by fear, unaffected by favoritism, unaffected by affection, and unaffected by ill will. And this commitment underscores the importance of integrity, impartiality, and fairness in the process of adjudication. From my experience, I speak here that of all the attributes a judge is required to possess to perform his or her role as backbone of human rights enforcement, I consider 2 of such attributes as towering and outstanding. They are character and courage. A judge must be a person of character. A judge must be a person of courage. And I say here that if these 2 attributes are found in a judge, all other requirements, are covered. So, character and courage are indeed the most essential attributes for judges. A judge with strong character and courage is well equipped to uphold all the requirements of ethics and codes of conduct. Judges with strong character possess high moral integrity. They possess honesty and ethics. And character-driven judges, they will remain unbiased and fair in their decision-making. Such judges also inspire confidence in the justice system. In the same way, courageous judges make decisions independently without external influence. Judges with courage can make very difficult decisions, even in the face of the most scurrilous criticism and pressure. And I want to make the point very clear that the reality of the work of a judge is that they face pressures. There are pressures that judges face. I mentioned here, I had the fortune, I will not call it the misfortune, of handling many sensitive and high-profile cases while on the bench. Some of those cases put me in direct confrontation with the government, such that I was tagged an anti-government judge. I am not sure I was. I was only doing my job, administering justice. Such cases also put my career on the line, and they also put my life on the line. Sometimes I had to go to the trenches to ensure that independence of the judiciary was maintained and justice dispensed. It will actually surprise you to hear this, that a judge will go into trenches when he is not somebody like Professor Dinkalu or Aisha Yusufu. But what I experienced, as we go on, you will see, pushed me into trenches. So, reflecting on my active years on the bench, I can only say here that I thank God that I survived the vicissitudes. And to the glory of God, my career came to a glorious end. And I am alive today to share my checkered experiences with you. And it is all about justice, all about independence of the judiciary, which I believe very strongly must be preserved in all circumstances. The concept of independence of judiciary is not an esoteric term. In the context of our discourse, it is seen in the light of the simple definition of the concept provided by the International Commission of Jurists, that every judge is free to decide matters before him in accordance with his assessment of the facts and his understanding of the law without any improper influence, inducement, or pressures, direct or indirect, from any quarter or for whatever reason. The phrase "from any quarter" or "for whatever reason" is underscored here because it includes the judge himself. You may have all the provisions of the Constitution, guaranteeing the independence of the judiciary. But the question will still arise, what about the judge himself, who may not be free from his or her own timidity and timorousness? In this vein, judicial independence is not just a jurisprudential notion. It is an expression of commitment to justice, freedom, and rule of law. An independent and impartial judiciary is an institution of the greatest value to the democratic society required by law, and it is an essential pillar for the liberty and the rule of law. In some climes, the battle for independence of judiciary had been won, though not on a platter of gold, but it had been the work of ages to establish and the sacrifices of courageous men to attain. In Nigeria, it is still work in progress. That is why Nigeria needs courageous judges who will not compromise justice on the altar of inducement, threats, or intimidation. Judges who will make decisions solely based on the law without fear and favor. Judges who will bravely face threats or intimidation and still prioritize justice and integrity of the judicial system. Unarguably, judges face a multitude of pressures that often influence them. These pressures come in different forms, different dimensions, different characters, and different colors. They also come from friends and relations who may be acting as emissaries or who may be acting as conduit. These people are usually carefully chosen, or the presumed influence, they are carefully chosen on account of their relationship with the judge or the presumed influence or what I call undue influence here, they think that they can bring to bear on him, that is on the judge. And the truth is that few Nigerians believe that you can obtain justice in court without reaching out to a judge. True or false, though? I don't know. I'm asking you. Few Nigerians believe that you can receive justice in court without reaching out to the judge. That is a perception, and it's unfortunate. But by far, the most worrisome exertion of influence on judges comes from the executive branch of government. There are people in government circles whose perspective of the judiciary appears to be distorted, viewing it, that is judiciary, as a subordinate department or agency rather than an independent branch of government. And this mindset leads them to wrongly perceive judges as mere instruments or tools expected to implement their directives without question. I want to tell you here, with every sense of humility, that I experienced some of these pressures during my career as a judge. But due to constraint of time, I will highlight two notable cases to demonstrate my points. And incidentally, they are the two cases that Professor Dinkalu mentioned. Umaru area and another versus Kogi State House of Assembly, 2009, All Federation, it was quoted, All Federation Weekly Law Report at page 343. I also had Ajana and another Kogi State House of Assembly. I reported it in my book, In the Interest of Justice, Excellence in Judgment Writing. So the two cases had to do with the removal of chief judges. And the problem we had is the constitutional provision of removal of judges. And that is section 292. You know, it prescribes the way judicial officers shall be removed. To me, the provision is fluid. Yet, up till today, it remains unaltered. I don't really know why. Both the executive and the legislature often take advantage of the fluidity of the provision of the Constitution to abuse the same with recklessness. Twice in Kogi State, attempts were made to remove chief judges, and I had the honor of handling the two cases. Let's look at the constitutional provision. You will see how fluid it is. Go straight to section 292, 2. It's about chief judges. All it provides here is that chief judge of a state, grand cadi of the Sharia Court of Appeal, president, customer, all these heads of court, anyway, they shall be removed by the governor, acting on an address supported by a 2/3 majority of the House of Assembly of the state. In other words, if the House of Assembly can simply pass a resolution for the removal of a chief judge with 2/3 majority, that is the end of, well, according to these provisions. If they can pass it, praying that he be so removed for his inability to discharge the function of his office or appointment, whether arising from infirmity of mind or anybody, or anything for misconduct. You know, these are the reasons for misconduct or contravention of code of conduct. So you will look at this provision as being very simple, a very simple process to remove a chief judge. And politicians too, they wrongly consider removal of judges as a political issue. Accordingly, it is easy to allege misconduct of a chief judge on flimsy grounds because misconduct is not defined under the Constitution for purposes of section 292. So anything can mean misconduct under section 292. Misconduct, therefore, becomes an eccentric word, often abused, and the abuse is such that the chief judge, it will be termed a misconduct. And I've cited the example of Justice C.J. Ajana. What was his problem? It was no more than the fact that the governor wanted to control the salaries of judicial staff. He made the secretary to the state government to write a letter to the chief judge to submit the payroll of the judiciary for a pay parade of civil servants in the state. The response of the CJ Ajana to the SSG's letter was a polite decline to the request and a gentle reminder that the judiciary was not a parastatal or a government under the government of Kogi State, but was one of the three arms of government. What followed next was the passage of a resolution by the Kogi State House of Assembly for the removal of the chief judge. I don't know if you follow what I'm saying. Bring your payroll. Eventually, what was going to be done was that the salaries of the staff of the judiciary will be paid from the government house. So, Justice Ajana said, no, we are an arm of government. And so, that's all about independence of the judiciary. We cannot submit our payroll to you. And the next thing was a petition to the House of Assembly, and the House of Assembly, what they did was to remove Ajana straight away. So in my judgment, in that case, I stated that I find a dubious and conspiratorial siege of both the executive and legislature of Kogi State against the head of the judiciary of the state. And I added that there appears to be an unholy alliance in which the legislature subjugated itself to the overbearing power of the executive to subdue the judiciary under the guise of carrying out a phony investigation. So, I will go now to the substance of the pressure that we are talking about. For you to know that judges, they pass through a lot in some of these the high-profile cases. So I take, for example, the Aries case, where I experienced what I would describe as subtle threats, intimidation. And how did it happen? I was a young judge, barely 2 years on the bench, and when that case was assigned to me. And so what I started to receive, they were emissaries. And when I talk about emissaries, I am talking about highly distinguished personalities in the society. They came, in actual fact, sometimes to express very genuine concern about you, about your career, and about your life. And so, what, they were saying then, they reminded me that, Eri that you are talking about is at the twilight of his career. Of course, the man had just 3 months to retire from service. After about 40 years in government service, he had 3 months to retire when he was dismissed from service through that resolution. And like Professor Odinkalu said, what we had was that there was an election and there was an attempt to use him to do whatever he wanted, whatever was required. Ultimately, it didn't succeed. That governor was removed by the tribunal. And so immediately that happened, the next thing was to allege, make certain allegations against him. The matter went to the House of Assembly, and before you knew it, the man was removed. So people came. You know you're a young man. You know you're just starting your career on the bench. And so this man is about to conclude his own career. Why do you have to put your career online because of a man in that position? They also ask questions such as, why can't you allow another judge to hear this matter? And of course, we also had, are you the only judge in the state that can handle it? I mean, you can imagine the type of effects such things will have on you as a young judge. And these ones are not your mates. So I am talking about highly influential people all around there. So such were the messages they came to deliver, but I was not moved. I was firm in my stand that if it was accepted that the case must be heard by a judge, why not me? If, as it came to be filed before my court. So their expectation actually was that I would just come to court one day and give a very flimsy excuse and withdraw from the case. But this didn't work. So their subtle threat and intimidation did not work. I mentioned the man had only 3 months to retire. So assuming after about 1.5 months of trial, I now decide that I was recusing myself. I don't know what will have happened. So that was a particular level of pressure, and judges experienced this. I completed the hearing of the case in record time, within 40 days, and the case was filed. The case was filed on 17 April, and judgment was delivered on May 18, 2008. And Eri had, as at the time I delivered my judgment, Eri had only 45 days to retire from service. There was no type of attempt they did not make, the lawyers, to delay the hearing of the matter, of course, meaning that to buy time. I don't know how many interlocutory applications that they brought. So what I did to defeat that attempt was to consolidate the hearing of all the interlocutory applications. And I delivered their rulings along with the judgment on the same day. And that was why I was able to complete it in record time. That was not enough. Let me tell you here again that a day to the date of the judgment, something terrible happened that I could not imagine. The CR was summoned. And the CR came to me. It was after office hour. He came to my house with a report. You are not to deliver this judgment tomorrow. I said, why? Well, that is the message I brought from the government house. You are not to deliver this judgment. I said, but assuming the judgment is ready, so what do I do? It means I will go to court and will tell lie and say I was adjourning the matter. So I felt disturbed. You know, I told you there were some of the cases I went to trenches. At the end of the day, the man ended with a statement. My Lord, the message has been delivered. Wow. That statement to me was loaded. And I felt, what will I do? Well, an idea came to my mind that tomorrow, if you are going to court, don't follow your usual route. But how will I do it? Because Lokoja to Kotonkarufi, where I was sitting, there's only one road to that place. So I called my wife and explained to her, I'll be traveling to Abuja. So, well, I put her on notice in respect of that. So that evening, I didn't sleep in my house because I wanted a situation in which I would not follow my usual route to the court that day. I was going to come from the opposite direction of my usual route. So I took off. I was coming to Abuja. I got to Jegubeki, and I just looked by the side. I saw one new guest house being built. It's still there, if you know Jegubeki, beside the petrol station. I told my driver, please, let's check this place. We got there, incidentally, new, but it was open for use. So they said, instead of going to Abuja, why can't we stay here? So we stayed there. In the morning the following day, I left Jegubeki, coming from Abuja direction to enter into the court. And I entered into the court sat. The judgment that I was asked not to deliver, I delivered it very confidently. Now, the experience in Justice Eri's case, I want you to compare it with the experience of Justice Onoge. You can see my determination to see that justice was not only done, but speedily done too. What happened to Onoge? Honorable Justice Onoge, former CJN. What happened to him was what will have happened to Eri. You remember what happened to Onoge? What do you call it? A code of conduct tribunal that everybody knows has no jurisdiction. You know, entertain a matter and asking the Chief Justice of Nigeria to step aside. And of course, that was the end of his career. Then, we also know that immediately Justice Onoge appealed. I mentioned in my paper here, he filed 3 appeals. When Justice Onoge appeared before the tribunal, he raised objections challenging the jurisdiction of the court to hear and determine the matter, having not been brought to court with due process. And of course, by the fact that NJC didn't hear anything before he was flung into the tribunal. So the tribunal ruled against him. He filed 3 appeals, and the best of the lawyers in Nigeria went to the Court of Appeal to argue the appeal. The appeal was argued, and of course, that was in 2019. Appeal was argued in 2019. When was the judgment delivered? Judgment was not delivered until November 4, 2024. 4 years, the lifespan of a government. I don't know if there's any message that has been passed there. So it was in the same way. I was not to deliver the judgment. so that Eric will retire, and retire with the ignominy of having dismissed from service. And of course, that will have been on his neck forever. So, when I reflect on Justice Onongen's matter, how I wish that upon appeal to the Court of Appeal, within 1 week, or within 1 month, or within 3 months, the matter was resolved and another made reinstating him. But that didn't happen. So, and I want to recall the statement of Justice Sisin Wenze of blessed memory to say that, or let me adapt it now to Onongen's case, that the shabby treatment that the judiciary treated one of their own, not just one of their own, the head of the arm of government, will continue to haunt the judiciary forever. So, I say here, area obtained judgment. Eventually in 2024, when Onongen's case was delivered, I learned a lot of damages were awarded. But I still ask, can we say, in all circumstances, that Onongen received justice? Well, I think it's a question that you have to answer. I moved to Ajana's case, and I describe it here that it will go into record as one in which I experienced the most, or not the most, the crudest form of pressure. The crudest form of pressure. Because there was intimidation to my life. The police, my police security withdrawn from my court. And I was thrown, into the vagaries of thugs, attacks of thugs and what have you. I begin with the intimidation to my life. Yes, one day, somebody came to me and said he was just coming from a meeting in which a decision had been taken that I should be eliminated because of this case. And so he offered a counsel to me that he will advise that I should leave the town, and find a place to go. Well, I thank him for the information, but I asked him some pertinent questions. Number one, I asked him, if I concede to your advice now and I leave the town, does it mean I will not come back again? I said, okay, if for any reason, for the period that you say I should go, they don't find me here, if I return and they are still determined to do what they said they wanted to do, so what will happen? So I said, living at the house, traveling out is not the issue. Then again, I drew his attention to, I said, look at this house. The children, they are out of the house, all of them in different places. Only my wife and I, except in the other house where we have nephews and nieces that we are caring for. I said, okay, if I sit to your counsel and I leave the town, and they come, they don't find me, and they find my wife. So, assuming they are still determined to carry out their whatever wicked act, so how will it be that because I didn't even want my life to be taken, I left my house, and my wife, was met, and if any eventuality happened, I said, how will my life be after that event. And finally, I struck him again. I said, do you see me now? I said, that time I was just slightly above 60 years of age. And I told him the story of my own life. I said, my immediate senior brother died at the age of 12. My immediate senior sister, they died on the same day. On the same year. Probably too, she was 6 years old. Perhaps around that time, I was 9 years old. I said, my immediate senior brother, they are no more. And if God can keep me up to the point that today I am 60 years old, I think I have every cause to thank God. And if I die, they will not say a young man has died. How many minutes do I have left? Yeah? 5 minutes. Okay, all right, 5 minutes. So anyway, so these are the pressures. But then, finally, we talk about pressures and principles. With all these pressures, I mentioned here that through determination and perseverance, I overcame the hurdles that stood in my way in the way of justice in the 2 cases and deliver conclusive judgments, advancing crucial legal principles and providing clarity on key issues. And with every sense of humility, if you hear today that there's a principle in law that before any judge can be disciplined, his case or her case must be reported to the NJC. I want to say that somebody standing before you today was the one who established it. How did it happen? In 2005, all the judges, if ever they were removed, chief judges, nobody contested the matter. So in 2000, I did not have any precedent to follow to secure. I have explained how simple it is to remove a chief judge. If you don't know, the tenure of an ordinary judge is more secure than that of a chief judge, because the process of discipline is required, and also, so a chief judge, resolution of the House, 2/3, you are gone. And that was it. But what I did was to try to strain the letters of the law. And I found that I reasoned that if a man or a woman is going to be removed, that should be treated as an act of discipline. It means you are disciplining that person. I now took the case of any allegation that will make a chief judge to be reported to the House for removal as an act of discipline, and therefore it should come under either the 5th schedule, I mentioned it here, and item 21 of that schedule of the Constitution. And so I now came up with if you see my paper, you see it. But in summary, I came up with the principle that act of removal of a chief judge is an act of discipline against him. And that item 21 of that schedule in the Constitution confers the power of discipline on the NJC. And I said, so which means that provision cannot be bypassed. The case of a chief judge must first be taken under that item. In other words, must first be taken to the NJC before it is taken. And so today, you hear about it. This case didn't go on appeal, but my pronouncement is here. And for want of time, I will leave it. But what happened was that shortly after, the chief judge of Sokoto was also removed unconstitutionally. Shortly after Sokoto's, the chief judge of Kwara State, that was Ralia to Elelu Habib, it was she who took that matter to the Supreme, fought it to the Supreme Court. And this principle, I was not acknowledged, I was not, but that principle now remains the principle in the case. So, my conclusion is this. If you read I made some very serious pronouncements. Sorry, and one of them is about government. Government ought to govern by example. In one of the cases, I say, we live in a country where the government professes to the whole world that it is operating under the rule of law. One important way to encourage respect for the rule of law is for those who are in authority to demonstrate by their conduct that the law that they make, execute, or administer, as the case may be, also binds them. They must validate the fact that they do not constitute an exceptional group that towers above the law. Indeed, it is the challenge of the government to govern by example. So, what type of judges do we need? My conclusion is that we need judges who are learned in law, not merely in law of the books, but something far more difficult to acquire. The law as applied in action in the courtroom, judges who are deeply versed in the mysteries of human nature, who are adept in the discovery of the truth in the discordant testimony of fallible beings, judges beholden to no man, independent and honest and equally important. Judges who believe by all men to be independent and honest, judges above law, fired with the consuming zeal to mete out justice according to law, every man, every child, every individual, and right to fight for freedom against any aggression of government, judges, and so on and so forth. And I ended by saying that the type of judges we need, I leave the podium. They are judges who will see any case in respect of, because you are waiting, so that I can meet on the way. I don't think it's that way. That way. I am still delivering my paper.
Thank you so much, Honorable Justice Alaba Adile. We are so grateful for your insightful paper. That was very powerful. Thank you so much. A case has been made today, and it will inspire and really lead the conversation. Let me, of course, recognize some of the special guests that are here. Start with my Oga, Clement Chukwemeka Owochukwu, former second vice president of the Nigerian Bar Association. Thank you very much for coming. Let me recognize Anthony Bamdele Ojo, the chairman of the MBA Gariki branch. Thank you very much, my boss. Also, Ezinwa Numu, thank you, my boss. I don't know where he's gone. Thank you very much. Let me recognize Ozioma Izuora, a former vice chairperson of the MBA Unity Bar. Thank you very much, ma. Thank you for coming. Mary Asom, Lex Initiative. Thank you, Mary, for coming. And let me recognize my boss, Mohammed, from Nulai. Thank you very much for coming. Then Emeka Oswani also was supposed to be here, but is ably represented by Adakole Isaac. Thank you very much for coming. Those of us who have practiced for a little bit and interacted with the CAC for some time will never forget the name of Azuka Azinge. If she's here, please, a round of applause for her. The reform she brought to CAC made our lives so much easier back in the day. We are grateful to you. Thank you for coming. Then Bridget Shehu, the Senior Legal Analyst, Office for Strategic Preparedness and Resilience, Osprey, thank you for coming. It's good to have you here. Of course, it's time for Aveve Kuve. She's a woman of courage. Her posture and picture lives rent-free in our minds. From the days of Bring Back Our Girls to now when she has just refused to give up. When they accuse her, she'll come up with evidence of all the party agents that she has paid. She's a woman of very strong character and with a deep sense of humility. Aisha has been a formidable force for good in this country, and she's a force of nature. Ladies and gentlemen, please join me and make welcome the formidable Aisha Yusufu.
Yet again, distinguished guests, champions of justice and advocate of freedom. Ladies and gentlemen, please take a deep breath, because what you're about to witness is not just a speaker. She is a movement. She is a voice. She is a force of civic fire, born in the historic city of Kano, raised in a society that tried to silence girls before they could speak. She broke through barriers, she chose books over boundaries, and transformed her life into a bold blueprint for national outreach. A scientist by trade, a strategist by experience, a revolutionary by purpose, she co-founded the Bring Back Our Girls movement, turning the world's gaze to a forgotten tragedy and the nation's conscience to long-ignored cries. Through fire and fear, through storms and sneers, she stood firm in the front line of the NSAS movement, confronting power with nothing but conviction. Veiled in strength, rooted in justice, and voiced in truth. She's the founder of Citizens Hall, training the undeserved, equipping the unheard, empowering Nigerian women and citizens with financial literacy, political courage, and the power to demand good governance. Her awards include BBC 100 Women of the Year, Martin Luther King Award, Voice of Humanity, Guardian Newspaper, Funmilayo Ransom Kuti Human Rights Laureate, 100 Most Influential Africans, New African Magazine. This is not the kind of woman history forgets. This is the kind of woman history writes about. A civic crusader, the mother of movements, a lighthouse in Nigerian darkest policy nights, a voice that cannot be silenced because it echoes in the hearts of millions. With thunder in her words and courage in her stride, please applaud as we welcome the fearless, the fierce, the phenomenal Aisha Yusufu.
Thank you so much. I don't know what they are talking about. I'm simply Aisha. Where do I start from? First of all, let me just say, I don't do protocols. I don't believe that I should be calling people who haven't done an excellent job, Your Excellencies. Neither do I believe that I should call people who have not distinguished themselves as Your Distinguished. I do not also believe that people who have been dishonorable, that I should call them honorable. Neither also do I believe that those who have not protected justice and equity, that I should call them Your Lordship or Your Worship. But I stand before you today to say to Justice Alaba, I hope I got that correctly, the first pronunciation, that I am proud to be able to say to you, my lordship or my worship, whichever one it is. So you bear with me. I'm in microbiology, so I don't know much. Dear citizens, fellow citizens, ladies and gentlemen, Good afternoon. I'm here to talk about independence, of the judiciary. And there's no way we can have an independent judiciary if we don't have citizens who are independent. If we do not have citizens who believe that they are part of the society and that they matter, there's no way we can. I used to say judiciary was a problem until I realized that judiciary, it's not the problem. The people in the judiciary are the problem. And until and unless we understand that it is indeed the people who are there that are the problem, and we begin to look at them one after the other and call them out, we are not going to get anywhere. As a young girl, by the way, I'm also in my 50s, so 50s club. As a young girl, I read The Incorruptible Judge, and it stayed with me. And just a few moments ago, I saw what it meant to actually be incorruptible. I mean, to be able to stand in front of people and say that there was no precedent, I set the precedent. How many do we have that can say so? Indeed, when we talk about the independence of judiciary, it's not just only a legal issue, it's a human rights emergency. Where we are today in our country, we are here because of the people in the judiciary who did things they ought not to have done. The judiciary is supposed to be the last resort of the common man. Today, it's the plaything of corrupt politicians. They go about shopping for judgment. I'm from Agbede in Edo State. I live in Agbede, or I live in Benin. I will leave Benin. I will go to Dutse to go and file. Why? Entrepreneurship, because I need to get something. That's where we are today. There is supposed to be a separation of power, but unfortunately, there is none. Today, I was asked to write a paper and read the paper. But what is it that needs to be said that hasn't been said? I'm here today to talk to you, heart to heart, a Nigerian to a Nigerian, and say to every one of us, what are we leaving for the younger generation? I think a few days ago, there was a judgment where a former governor, I saw Professor Odinkalo tweeted it, and I was like, by the way, I beg, if I ever say I want to fight Professor Odinkalo, me wanna advise me. Me wanna advise me, because the real coconut head, na there it is. I mean, go at him at your own peril. I know the case he has had in Kaduna. And he said something very instrumental when he retweeted, a newspaper publication. He said the former governor of Kaduna State used to win all his cases, except for one. But since he became former, he has been losing all his cases. I think that says a lot. And even though for a number of times, sometimes we are angry, but when I heard, the statement that even the judiciary have not been able to stand for its own, it's really sad. It's sad when you see people, judicial officers, who have refused to bow down to the corruption and the threats that are being put out at them all the time. The way that they are being treated in our community. And instead of the incorruptible judges, incorruptible judicial officers, to be the ones to raise their head high up and walk proudly in our country, they're the ones who are shamed. Even their own family members sometimes say, can't you do like the other people? Everybody is doing it now. What do you want to prove? That you're the only one? But sometimes it's okay to be the only one, right? Sometimes it's okay to say, no, it's not about the wrong thing being done. is the right thing being done. Because like I always say to everyone, you know when they say, are you not afraid of dying? Death is not when you can no longer breathe in oxygen or bring out carbon dioxide. Death is when you do not speak or you do not act in the right way because you are afraid of dying. For indeed, when a man and a woman get to that stage, they're already dead. Today we have politicians who will say to you, and when I say politicians, corrupt politicians, who will say to you, go to court, because they know the courts are in their pocket. But it can change. It can change. And every one of us, when we understand the fact that it is made up of individuals, you and I, in every institution that we find ourselves, that we are the ones who are the protectors of our nation, of our ideals, of our beliefs. We are the ones to carry on integrity and character. We talk about our heroes past. We heard Professor Chidi Odukalu telling us, indeed, those heroes past might not really be heroes past. It might be a matter of which one worsened as we went on. So what then do we owe? What then do we owe the unborn generation? We must stand and ensure that this independence that we are talking about, that we take it upon ourselves, that every one of us will do everything that is needed to get that judiciary that is truly and absolutely independent. That even though at the time of our independence, the judiciary that we were given was not independent, then it beholds on us to build a judiciary that is independent. Because without an independent judiciary, there would not be a nation. That's why we are here. As a business person, the person who has wronged you, who has eaten your money, who has refused to pay you, is the first person that will take you to court. The first time I ever appeared in court, it was someone I paid in 2008. I'm a businesswoman, by the way. And I was going to go into haulage business. And I paid him to do trailer bodies too for me. He collected my money. He didn't do it. I kept going. I reported him to the police. We kept coming back and forth. The next thing, he went to court. We have a nation where those who do the wrong thing are the ones who are quick to go to the courts because they know it is either they will be able to bribe their way through one way or the other, or they will keep postponing it until you get tired. I wasn't tired. I stayed on. I won that case. And then, what do you call it? I countersued. I didn't get my money. I got the bodies that he had done, and I went on, finished it in another place. I started our business. In 2009, I started our business. But by 2012, I was done with the Agbere work, fighting with drivers every day, all of that. But do you know that the lack of independence that we have in the judiciary also affects our business lives? It also affects a whole lot of things. There's no trust, no confidence. Many a time you wonder why people who go on to negotiate with terrorists or meet terrorists come back almost sympathizing with them. Because every Nigerian that you see have a story of injustice that has been done to them. And when people say to us that Nigerians do not react, that whatever you do to Nigerians, they would never do anything, I said, no. A lot of Nigerians are doing so much, but they are not doing it within the ambit of the law. They've taken the laws into their hands because they no longer believe in our judicial system. And how do we ensure that there is that belief in the judicial system? Men and women who are there must say to themselves that indeed they would stand. This is not about a system. This is about every one of us. This is about everybody who is in there. What is it that you are doing to ensure that truly the judiciary is independent? Sometimes we want favors that favor us, right? And then at that moment, you will justify the lack of independence of the judiciary. we must be honorable enough to understand that whatever it is that we do, we must ensure that it is for the greater good, even though it is against ourselves. And so yesterday, the judgment that I read that had come from Kaduna, and it said that 900 million was awarded, right? To, is it, am I get this wrong, that please pardon me, I think Adara elders in 2019, the then governor, Nasiru El-Rufai, had gotten them to be arrested, you understand? And now there was a judgment on that. So what we have now, just for us to understand how important, how the fact that if we want a nation where rights are enshrined, that indeed we must have that independent judiciary. And now you have this in judgment against him, and also the Nigerian police. Unfortunately for us, the Nigerian police has allowed itself to be a willing tool of oppression at all times. And the Nigerian police was also asked to pay something. I think their own is 10 million, the IG of police, and also the Nigerian police 10 million. But that's something. To say that you cannot arrest somebody just because you want to, just because you are a governor or a minister or whatever it is. And if we have our courts doing this, guess what will happen? The police themselves will understand and would no longer allow themselves to be willing tool of oppression. And if we do not have as much oppression, people will be able to speak up. And when people speak up, rights will be enshrined. And a whole lot of things will be done well. The nation today that every one of us, we are praying to God. And by the way, God will not do for us what he has given us the capacity for us to do for ourselves. If all of us sat down at home and we didn't all come out here, we wouldn't hear each other, no matter how hard we pray. And so sometimes when we sit down and we're praying about Nigerian issues, it's not about prayers. It's about acting, using those tools and those resources that God has given us to build a nation that every one of us can enjoy. And so we must do everything to put it in, build that nation that we all are looking for. And when people who think they are in power, who think they own everything, realize that we have a judiciary where the rule of law is sacrosanct, a judiciary where equity is sacrosanct, where justice is sacrosanct, where it doesn't matter who you are, it doesn't matter your position, it doesn't matter your gender, your age, neither does it matter what you have, but it's all about the rule of law, the Constitution, and ensuring that justice is done. If we have that kind of judiciary, a lot of things will get in place in this country. Never again would we have people, just because they were elected into office, begin to walk over our heads as if we are nothing. And by the way, even most of the corrupt politicians that are in office today, they only got there because of the judiciary. Yeah. Tribunal, they go to the Supreme Court, and then they leave us. We don't hate the judiciary. When we make demand, there was something that Professor Chidi Odikalu said. He said, when people are angry at you or talking to you, it means they care. We care. We don't abuse anybody. We don't insult anybody. But in this country, when you say somebody is corrupt, someone who is actually corrupt is corrupt, or someone who is inept is inept, or someone who is clueless, they say you are insulting. Why don't we find it insulting that those who are supposed to do what they are supposed to do are not doing the things that they are supposed to do? Why do we find it okay that our lives are being wasted? Yesterday, children wrote exams, WAEC. They wrote it in darkness. They were failed not only by their system, by their government, by their country, but also by their parents and every one of us here as adults. We sit down, we tell these children to respect us. Have we really done anything that is worthy of respect? I used to be angry at my father because my father would tell me stories of how when they were in the university, they will share chicken. They even had to fight when they decided that is it 4 people we have chicken or whatever. Those stories that you all hear. And I said to my father, why couldn't you keep that Nigeria for me to also enjoy? The Nigeria I know of as a student is that of us who striked and wasting of years. When I'm supposed to graduate in 4 years, I spent 10 years in the university. But guess what now? I have not been able to keep the Nigeria that I met for my children. And we ask them to respect us. In what way? Like I said earlier, if we want a judiciary that is independent, we must have a society where people are truly independent. The first set of dictators that we as citizens came across were actually our parents. We, parents. We've also been dictators. We do not allow our children to speak. There's no democracy in our houses. They don't speak up. You're told, keep quiet as a child. And the students that were here earlier, Professor Chidi Odinkalu addressed them. But guess what? You'll be failed just because you have independent mind. I'm currently in school. I'm doing my first degree. I'm doing BSc Economics. Some semester ago, I did something. And I got such a shabby marks. I think I got like, is it 8 or 9 over 15? And I wrote to the lecturer. And I said, can you just explain to me what I did wrong so that I will get it better in the exams? And he said, I didn't use his notes. But why am I supposed to use your notes? Children are punished if they write something out of what they are taught. So we are taught not to critically think. We are taught not to be independent. We are taught just to accept whatever it is that we're being told. And as we go on, because we're used to that first of dictators as parents, then you go on, you met your teachers who told you that you couldn't think out of anything that they taught you. You couldn't bring in anything new. And then we have the religious leaders who continued it. Guess what? We all became adults and we replaced our parents with government or authority. And that's why they will come to you and say to you, are you the only one? For a while, when Justice Alaba said, is it something CRO or something? I was like, what's CRO? What's CRO? Then later I was like, I think it's registrar. Am I right? Something about a registrar. How shameless can one be to meet someone who is way junior than you and say to that person, don't do the right thing? We are that shameless in this country. And when I say we, I mean all of us. How many times do we refuse to stand when we see that red light and we go on? A father lost a son recently because he did the wrong thing. He drove one way. And he ended up losing a child. The police went ahead to shoot. These little things. Even though some came out to say, his nephew came to say, all my uncle did was to go one way. Yes, it's bad, but it's not that. But guess what? There were a lot of people who came out and talked about how they lost loved ones who had just gone one way. I always say, everything is about opportunity. If you refuse to stand when you see that red light, it's the same justification. Oh, I'm in a hurry. Oh, nobody is here. Oh, everybody is doing it. Everybody is doing it can never make it right. And so the same way is how you get to that place where you're supposed to be the one telling the younger generation, the upcoming ones, to do the right thing. But indeed, you end up being the one telling them to do not the right thing, to do the wrong thing. And they always use fear. 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 The religious rulers will use fear. Loved ones will use fear. People will say, I'm afraid. Are you not afraid of being killed? Citizens are dying every day. And I've known we've stayed here so long. We're supposed to start by 10, right? It's after 2. So I'll make it short. But citizens are dying every day. People are losing their lives. What makes us think that our life is more special than those who have lost their lives? And if whatever you do on this earth, forget you are in office, whatever it is that you occupy, there are a lot of people who have been there before you. The question I always say to people is, in 100 years, who will remember what you did? Will your name be remembered for good, or will it be remembered for something bad? Will you have set a precedent that will go a long way in freeing people? At every moment that we have, let us take our country as one that we all have to do something about. And please remember what I said earlier. It's not the institution, it's the people. And for every one of us who is silent, when we see the good judges, the good judicial officers being punished for doing the right thing, we also are part of the problem. When they are taken to that office or that court where there's no electricity, or their security withdrawn, or they are pushed to somewhere, where as in they'll just give you file. We want to waste your career, and we do not do anything. We also are part of the contributors to the lack of independence that we have in that judiciary. So if there's anything, one thing that I hope I would have communicated to you today, is for you to say, what is it that I can do in my little space to ensure, bros, if you waka come here, all this English where I go speak, I go drop and where I there, so. You know, say I be Niger Delta woman, be. That trench is will do there. I'm going because now so you give everybody time now because me no read law. Are you marginalizing me because I'm a microbiologist? Is that it? Bros, calm down for me. Okay. If there's one message, and I'm going to end now, it's for every one of us to know that silence is not an option. That giving up can never be an option. That indeed we can have a country where we have an independent judiciary. We can have a country where access to good quality education is not dependent on the economic status of one's family. We can have a country where we don't have graduates who are leaving school without getting any jobs. We can have a country where poverty is normal, it's not normal. We can have a country where we are not the poverty capital of the world. We can have a country where others will be proud to come here, whether we come here for medical tourism. We can have a country where others will want to hold our green passports. That this present Nigeria that we have does not define us. We are who we can see. And every one of us, when we put our hands together, when we do the right thing, that we would have that country. And the next time they tell you that you might be killed, tell them that the victim card is already going around in Nigeria. Every one of us is a victim. That those who were victims yesterday, they were once survivors. Today's victims were yesterday's survivors. And tomorrow's victims would be today's survivors. And I ask you, who are today's survivors? You and I are today's survivors. And if we do not want the victim card to fall on us, if we do not want to be one of the numbers, then every one of us must stand up now and understand that we all must start for this nation and ensure that we get a nation where the child of nobody can become somebody without knowing anybody. Thank you.
Thank you very much. Thank you. Please, let's give her another round of applause. By the power conferred on me as the sole administrator of the Buhari chapter of the Women Forum. Let me commend a microbiologist for speaking so much truth on a subject matter that she almost doesn't have full grasp of law, but it's okay. I wasn't coming to cut her short anyways. I was coming to encourage her to keep speaking, even if, even if the time is short. I remember my own experience that I made a horrible mistake. I have a peeve for people that drive without seat belts and people that do reckless turns. Just you turn to another place without trafficating. So I would always just, try to admonish them. Wear your seatbelt, trafficate. When I got tired, I decided to go and join road safety and special marshal. And for that reason, my Thursday evenings are gone now because I have to find time to go and man checkpoints and do that responsibility. So if you're really angry about something, do something. Now is the time for us to interact with the speakers, and because it's important for us to deal with questions and answers. So if you'd allow me, I'd like to invite all the speakers. Aisha Yusufu, please, somebody should get her back into the hall. Let me invite Justice Alaba Ajile to please come on stage. Also, let me invite Professor Chidi Odinkalu to please come on stage. Let me also invite Ogundipe Yewande, who is the coordinator of the McGregor Gender Foundation. Please come on stage. Please help me get, the ushers should please get Professor Odinkalu, Aisha Yusufu on stage. Thank you very much. Let me recognize Mrs. Oge Abu, who is also here with us. Thank you for coming. If you're still here, we're grateful. Just a few days ago, the Buhari Law Week of the MBA did one of the best law weeks that has ever been held in the FCT, and the chairperson of the planning committee is here. The full Gen Chinyere Moneme, thank you for coming. It's good to have you join us. Now the time has come for me to invite the prof of all profs. I know the young generation believe that I don't give shishi started with Peter Obi. That's not true. We had an MBA election some time ago that I was a key member of his campaign committee, and he did not give shishi. In fact, that was the slogan too from our team. We don't give shishi. No entertainment, no refreshment, no upliftment. Ladies and gentlemen, he's a professor of character and conscience. Let's make welcome the very, very principled and very astute professor of law, Professor Ernest Ojukwu, Senior Advocate of Nigeria, the chairman of this colloquium.
A reformer, a guardian of justice, Professor Ernest Ojukwu, SAS, Senior Advocate of Nigeria, celebrated litigator, an architect of modern legal education, a man whose brilliance shapes courtrooms, classrooms, and the very conscience of Nigeria's justice system. As Deputy Director General of the Nigerian Law School, he revolutionized training for generations of lawyers, building the bridge between the academics and advocacy. As president of No Lie, he champions justice for the voiceless by empowering law students with their rights identity, modern leaders, and viable change agents. As a consummate advocate, he stands as a bulwark for judicial integrity. And today, we gather under his leadership, honoring the legacy of CO ANAH SAN. As Professor Ojukwu chairs his pivotal colloquium, the theme, the independence of the judiciary and the guardianship of human rights. Why does his chairmanship matter? Because when Professor Ojukwu speaks, the legal world listens. His insights are not just academic, they are battle-tested. From courtroom victories to policy reforms, he embodies the very ideals this colloquium defends. So let us lean in, let us learn, and let us carry forward the torch of justice he has laid. For in his words, we find not just wisdom, but a blueprint for a fairer Nigeria.
Okay, thank you very much. I need to give shishi because I know get himself. Right. Um, we'll allow the panelists to have their seats. And I know that we have spent some time. Maybe if we all sit down, and I'm sure this session will end in 30 minutes. 30 minutes. I don't think we should stay beyond 30 minutes. So it will be dependent on your questions or comments. The caliber of persons that you have invited to speak at this occasion, they are quite high, exceptionally high. One of the things that I know that makes me happy about Nigeria is that with all the worries and troubles, somehow it's an enjoyable environment, and to an extent, still free. And that's why Professor Chido Dinkalo will be able to come into Nigeria and go to 5 zones of the country in 4 days and still leave Nigeria and come back next week, and he's not in detention. I'm always afraid for him, and I always keep asking, where are you now? Where are you now? Where are you now? Because to know, so we'll be prepared for every second that he will be taken into a guard room. But he has survived this for 40 years. As a young student, he has already told that where we met, and as a young student, in fact, in his class, he was the youngest. Among them, he was very young. He had others like Pius Anyim. They were all in his class, and a couple of other older people. But he was also the only person that could challenge the teacher. And thank God, the subject I was teaching, criminal law, was my best. So they couldn't ruffle me badly. But he was the only guy who, and another colleague of his, who retired as the PAMSEC Minister of Justice in Ebonyi State, were the only people who could challenge me and argue with me over our discussions. And we have stayed close as colleagues ever since. And of course, my classmate Ajile, we have also, since we reconnected after many years, we remained very close friends and sharing events and the troubles of Nigeria together and all that stuff. So I'm happy to be in the program where they are. One thing that is the reason why Odinkalo can come in and go out, it's not just because the system don't want to touch him. It's because it's harder to fight honesty. It's harder to fight honesty. It's easier when to fight somebody who has some dirty hands somewhere. But when you are completely an honest person, your first protection is honesty, complete protection. Many years after my connection with Odinkalo, many years, 10 years after, I became the dean of the faculty at 35 years. And at that time was the height of cultism in the universities in Nigeria. And the worst were the state schools. And my particular university was in an Ireland where no staff lived. Not a single staff lived in Abia State University then, not even around the school. So the school was just by a mountain, and only students lived with themselves. No manager lived there except security people who were at the gate. So by 4:30 p.m., and so the university became one of the highest concentration of cult boys and girls because there was no checks and balances. And by 4:30 p.m., even the vice chancellor, we see him hurrying to drive out from the school. So everybody's driving out. And I was the dean of the Faculty of Law, and I was 35. And my history has never been one of not taking actions that doesn't hurt people. I always hurt people all the time. So you can imagine my reputation. And yet, I'll be the last to leave the school. 7 o'clock, and I'm going back to about 2 hours away. I'm not leaving. And at that time, they were shooting teachers, using knife on them, holding them hostage, beating them up. And I was dean for 5 years. I didn't have a single threat, not anonymous, not one threat. But I'll be the last to leave the school. And everybody knew that I'll be there because I'll park my car there. I had a Mercedes-Benz, I'll park it there. And everybody knew that. And I went to school 3 times a week, and you know when I'm there. And nobody ever threatened me. So and I was one of the most wicked teachers ever known. So the thing I found about it is that even the criminal understands honesty. Even the criminal understands honesty. And that's your first safety, your first protection. That one, you are going to just be truthful and honest. You are going to be fair to everybody. Once that is your value, then you have the first protection on earth. And that's why Odinkalo is still alive. And of course, you have heard my classmates' testimony. That tells you the story of honesty and fairness. The first protection. All that is driving around trying to find a hotel. He was even driving to the worst places. And so when he said, I'm not going anywhere, come and kill me here, nobody killed him. The first protection, and I preach that all the time, the first security, the first protection is honesty and fairness. So that's why it is so germane that Yusuf will talk about it, Aisha will talk about it strongly as a pivot for saving the country, that the judiciary must be fair and honest. That's all. That's why you talk about people, our colleague talks about, Aisha also cited those examples of running the red lights. Any guy who runs the red light is a dishonest person. It's not impatience. I always ask, when I do those kind of workshops, and I ask them, why people don't stand in the queue? Why do they break the queue? And they say they're impatient. I say, it is dishonesty. You don't know it. It's just a dishonest person because you are trying to cheat. That's what it's cheating. You're trying to run through the grass veg when there are 2 lines on the road. That's cheating. It's dishonesty. And that's the bane of Nigeria. And that tells me more about what is the hope for the country. I have always been a person who I've never believed that Nigeria will be better. But I have never stopped working to make it better. That's the contradictions I have. And I urge everybody, even if you're as hopeless as I feel, you must make it work better. But there is no second 11. There's no third 11. If you say the first 11 should be taken away, we don't have a replacement. Whether it is in the judiciary or anywhere, we don't have a replacement. Where are the people? Who are the people we're talking about that are the judges? That you expect majority of them to be honest. Who are the people we have appointed? That's the first problem. When we appoint them, as majority of our judges these days have been coming from the lower bench. When we appoint them at the magistracy, we don't pay any attention to the process. We don't pay any attention to the process. We don't pay any attention to the people they're appointing. We don't pay. But majority of them are going to become the judges. How? Are you going to manufacture them, recreate them? When we appoint chief registrars and deputy chief registrars, mainly from the ranks of the magistrates sometimes, we appoint anybody we like, and the next appointment for judgeship, the chief registrar must be on the list. Even if you don't make this today's one, you're going to make the next one. It's a must, unless you remove him or her. It's going to be and when you put them in a list, they are number one, priority list. And we don't pay attention, even as lawyers at the bar, we don't pay attention to the appointment of the chief registrar and deputy registrar. We don't pay any attention to it. We don't think about it. So where are you going to manufacture those people you expect to have judicial independence? Because as far as I'm concerned, it's not even what the government does to them or individuals do to them that is why we are having challenges with judicial independence. The only reason why we have issues with judicial independence is the individual independence, just as Aisha talked about our general lack of independence. So the human being is the key for me, not institutions. But what do? You know that now too, that what the government has been doing to many sectors of our lives here is now being done in US, where even the president will now start saying that they should impeach a judge openly. So the pressure is now back to US, where they are now pressuring judges. But you see, there are over 400 cases in some places now against Trump. And as they're filing the 400 cases, 200, 250 are against Trump. I filed a new set of 400, 250, 380 against Trump. It's just because the human being there has acquired, before the people they appointed, have some mental, honest independence. Otherwise, you must pressure them. You must fight them. So our problem is with the human being in Nigeria. No institution is a problem. The human being. And that's where I have hopelessness about. Because the majority of us are on the wrong side, on the left. The few people, the exceptions are on the right. And that's where the main challenge is coming from. We have experienced that in the bar. We have 2, 3, 4 choices for a post. And we all sit down and say, number one should be the best. Number 2 is the best. But you never reach that. Make the wait. Let's take number 4. And we know number 4 is corrupt. We know it. We know number 4 is incompetent. We know number 4 is going to do all those wrong things we are saying we should do. But it's the person that has paid our dues. It's the person that has given us dinner. It's the person that has given us money for a conference, for MBA conference, for SBA conference, for all the conferences. It's the person that is paying. And that's the person we are going to elect as president. But we know that other one would have been the best. So where are going to make the changes at the nation where we can't even make it at our local branch levels and national level? It's not going to work out if we are the problem. We have had, in every June, MBA branches conduct elections. Every June, they say, it's I think a 2-year tenure, but it's a June thing. And I think last month, I saw as usual, we have set up committees that will be the appeal panels for decisions that will come from the elections from these branches. Of course, 70% of the branch elections are going to be very poisonous. People are going to even fight physically in their branches. There will be heinous things that will be done against each other. And some branches will choose unqualified people for the elections. Open eye, everybody will know that this person is not qualified by our constitution, but the branches will choose them. And the appeal panels will approve it. In some cases, the branches have chosen the right person, and the appeal panel finds them not right because of their own personal decisions. And we have had decisions of appeal panels being overruled by past presidents of the bar because they were not right. So if you can get our judicial system, small judicial system at the MBA level, work, where are we going to get the big one work? Well, there's no hope for the country. we just can't continue to live as Chidi says, push me, I'll push you. Push me, and that's the only thing we can succeed in doing, at least to not to allow everybody to be swallowed at the same time. And that takes me to my final word about the person, why we're here, which is the only reason why I'm also chairing. CEO ANAH, who was a great friend, a senior friend, was a way big senior friend for me, but we're great friends. He had a deep respect for me, and if he recognizes you, he recognized you as hardworking, not intelligent, just hardworking. That's all that will endear you to him. And nothing you ask him to do for you, except, of course, he himself, that he will not do. He was that open and kind. He didn't value materialism. It didn't matter to him. It wasn't anything serious. So he had thousands of files of cases, but most of them were people he has charged, but they won't pay. And the juniors who want to stop, they say, no, you have to finish it. You have to finish it. So that's how he related. And I met him in court as a very young lawyer, and I saw how furious he was with advocacy. He was very strong, and how mean he was to judges who were half-half, who were fairly compromised. And he didn't spare them, even in open court. He didn't spare them at all. So, and I saw that, and I became chairman of the bar in 1997 in Aba. I became elected chairman. And suddenly, the Supreme Court brought out one case, Onyedero and Ebotola, or something like that, that declared that the High Court didn't have jurisdiction over customary right of occupancy, any land in rural areas, that the High Court didn't have jurisdiction, at least in places where they had the customary court. It was according to the land use decree, I think section 41 or so, it was the customary court that had jurisdiction. And then we had customary courts in Abia State, and some of us are practicing those customary courts in the first few years of our practice, and we knew what the customary courts were doing in Abia State. Customary courts were just a market square where you just exchange goods and services by paying your due, and they give you your judgment. If the more you pay, the more you get. And some of us, we felt very terrified from the Onyediro's case, or Abotolo's case, very terrified, because it meant in Abia State, 90% of the cases we did were land cases. In the East, of course, land cases. That's the only tussle we have. And that's the only thing that gave lawyers money, land cases. And so that meant that all our land cases, 60% of them in rural areas were going to be in customary courts, and we were terrified. And we had an emergency meeting, and everybody said, what do we do? What do we do? Supreme Court have said, go to the customary court. You can't go to the High Court. And we were all terrified. So, and I said to the bar, let me run a workshop. Let me run a seminar on this thing and see what we can do from here as Abia State against the Supreme Court judgment. And I just remembered CEO ANAH. That's that lawyer. Let me go to him. And I ran to him. I said, can you come and speak to us about this case? I didn't know whether he knew anything about the case or not, but I said, but I just wanted to come to this seminar and speak to us about this case. And I went to Justice Sofa, late Justice Sofa. I said, sir, can you be a panelist? Can you be a panelist in this matter? He said, okay. Well. So I got two of them. And that was the first MBA workshop the bar was having. So I assembled, the hall was full, yes. And CEO ANAH came there and dazzled everybody. And when they finished, we found that the Supreme Court had not even done us anything. So we found a solution. He said to us, if that is their problem, go and get the governor. Look at the Land Use Act. It says the governor can designate places, rural and urban. Go and get him to designate the areas you don't want customary court people to be dealing with you, urban. And then Justice Sofa said, but also the other way, is it not the claim of the parties that determine jurisdiction? We say, yes, sir. He said, okay. So if you say declaration for customary right of occupancy, that means you have taken it to the Supreme Court people. Yeah, we say, yes, sir. I said, what's their solution? He said, just ask for right of occupancy. Don't put it any name. And we saw two solutions. And so immediately after, I asked CEO to Because he didn't write any paper. When you see him writing, it's very short. His own writings are very short. If you saw what Chid said today, he didn't say anything. He didn't write anything. No. He just wrote 2 pages. And what he said, that's how I now used to do. He delivers very, very substantial matter, but nothing you can see in the paper. And I said, can you write me, sir? Write me this summary of what you said today, and now advise me. So he did that. He got back to then on the shower. Okay, I can't remember again. And he now wrote me a letter with the memo, and I did a memo, my own memo. I took to the governor, military governor, and the assessor. We want all lands in Abia to be designated urban. And he did, and he says, "That's all you want?" I said, "Yes, sir." The next day, the Attorney General issued the notice. And but it's a dangerous decision. It was a dangerous decision because right now in my village, if once you dig land, they will arrive, they will approval. They will mark it X. Mark it X. But it also has sped up capacity of our farmers to get mortgage, to get loan. Yeah, it has also helped them over years to improve their commercial. So CEO was a practical man, very, very honest, very exceptionally honest man who will not hurt a fly, but he will not stop speaking the truth, just like our colleagues here, Dinkalo, Ajile, and Aisha. We always say it to whoever was standing before them, you are wrong. This is the right thing to do. And he never stopped. He didn't bother whether you're going to deprive him of a judgment or a case because he has told you that you did the wrong thing, and as he saw you here, you shouldn't have been here, my Lord. You were there, you shouldn't have been in that meeting. He will say it openly, and he didn't mind how hot you become by your own actions because he was telling the truth. So that's the man we are celebrating today, and thank God, Ada has gathered the same type of people to speak in his memorial. We bless you. We're doing question and answer sessions and contributions. So please, we're going to, they have already done the work and we have spent so much time, but let's have from this group, please, one or two, then they will respond and we'll go. If we have any hands up or indications, yes, I can see my lady. Yes. Yes, do you have any here? Good. We'll just take all the questions, and then at the end, you just take notes. Yes.
Good afternoon, everyone. My name is Ibitoru Hart, and I'm from Bayes University. Good afternoon, everyone. My name is Ibitoru Hart. Good afternoon, everyone. My name is Ibitoru Hart, and I'm from Bayes University. It's an honor to be here today, and I learned a lot from everything that has been said. I understand the importance of the independence of the judiciary, and I recognize that the judiciary is being, would I say, regulated a lot by the executive arm of the government. I realize that the National Judicial Council, being the person that recommends judges, and the governor being the one that approves and removes, so it's very, I understand the sacrifices that judges have to go through to get to that position. So I feel like the reason why most people would not believe that we should be giving the judiciary independence is because they are confusing independence with immunity. So they believe that if you grant those judges independence, you can no longer control them. So my question now is, what steps can we take to ensure that as we are granting these judges independence, we're it's distinct from immunity? Like, how can we still check them while also ensuring that they are independent? Thank you.
Thank you very much. My name is Martin Atojoko from the Legal Assistance and Citizens' Rights Initiative. And I'm a private legal practitioner with my law firm as Martin Atojoko. My question, or what I want to know, is how do we deal with the issue of appointment of judicial officers and judges? Because fundamentally, if you look at the structure of Nigerian appointment of judges today, that is where the independence of judiciary really comes to question. People appoint judges, people are appointed judges because they are wives of members of the executive, or sometimes because their parents have opportunity to be judges. That is where I think the fundamental problem of the corruption in judiciary actually starts. Because he who plays the piper dictates the tone. So I put that before the panel today on this fundamental question: how do we deal with the appointment of judicial officers, especially judges? Thank you.
Distinguished Leonard Silks, my lords, erudite professors, ladies and gentlemen, good afternoon. My name is Adakole Isaac Abakba, the current National Welfare Secretary of the Young Lawyers of the NBA. I appreciate all that has been said and still ongoing in the course of this colloquium. I have a disturbing question over time that is yet to be answered. And I wish to direct this question to our erudite professor, Professor Ernest. I have reasons to believe that most recently the AML Act was enacted, Anti-Money Laundering Act, as well as several other beautiful laws. Nigeria is endowed with good laws, but my very challenge till date as a young man is the fact that we lack the willpower to implement these laws. So I wish to know if there are ways to which potency can be added to these laws to ensure that these laws work. Considering that we have technocrats, we have principalities who will not allow these laws prevail. So how do we navigate to chart the way forward in the course of adding potency to this law? Thank you very much, sir.
Thank you very much. Good afternoon. My name is Mahmoud Yusuf. I'm from the Network of University Legal Aid Institutions. My question will border around the issue of judicial accountability. My Lord Justice Alaba had alluded to the fact, and then Chidi also talked about, Professor Chidi talked about it, and Aisha kind of emphasized the need for us as a people to build institutions we want to see. So over the past years, we've been having issues around judicial, the integrity of the judiciary, and the lack of trust among the public from the judiciary. My question would be, how do we enhance accountability mechanisms within the judiciary, looking at it from the point of view of the National Judicial Council as it is presently constituted and what we have seen over the past years? Thank you.
Thank you, my Lord, distinguished panel. My name is Ogechi Abu, a private legal practitioner here in the FCT. Mine is more of a comment because this issue has been agitating my mind, and I feel that we may not get the maximum value of even an independent judiciary if we also don't deal with the issue of our legal system and jurisprudence as a whole. So Aisha mentioned the gigantic damages that was awarded a few days ago. But I can tell you that it's a victory, but it's likely to be a Pyrrhic victory. Empty. I can almost tell you for sure that in the next 20 years, those claimants may not receive 1 kobo. So, I don't know how we need to, because I'm thinking that this is a rider that may be necessary for us to take along as we address the issue of an independent judiciary. Because a situation where everything can go to the Supreme Court, even in instances where leave is required, I can say that I have hardly seen a situation where a court has denied leave. So these issues are not taken seriously. And even when we have judges who have the impetus, the temerity to be independent, we still do not fully receive the benefits of their activism because we are now stuck in the court system, clogged. And in the next 10, 15, 20 years, you are still where you were, in spite of the independence and bravery that might have been exhibited by the presiding judge. Thank you.
Otherwise, that one should end the questions.
Okay. Thank you, sir. My Lord, distinguished panelist, my name is Abdul Malik Zarouk. I'm from Didi Dodo & Co. My question is around the issue of the justices of the Court of Appeal in my Lord Justice Onagen's case, where they refused to deliver their judgment even when the appeal was argued in 2019, but the judgment was delivered in 2024. We understand that by virtue of the provision of the Constitution, Section 294, a court is obliged to deliver its judgment within 90 days from the hearing of the appeal. Even though there is a provisor in that law that, okay, that will, the non-compliance with that section will not prejudice the judgment if there is no any miscarriage of justice. But we can still say that as custodians of law, justices should endeavor to deliver their judgment within the time frame stipulated by the Constitution. And it should be a judicial misconduct if a justice fails to do that. So my question now is, in that case, what was the role of the NJC in calling out the justices who sat on that panel that refused to deliver judgment within the time frame stipulated by the Constitution? Thank you, sir.
We can take it off from here. Let's start with our lady, please.
Thank you, sir. Okay. All right. Thank you. I would like to address the question on the crop of, or the caliber of persons that are appointed into the judiciary. A valid point needs to be made. Judicial appointments are all constitutional provisions. They are contained in the Constitution. mode of appointment, years of experience and all that. I want to believe we might need to probably amend our constitution to include certain qualities or qualifications for persons being appointed as judges. Otherwise, we keep having this recycle of a judge's wife, an existing or a sitting judge's daughter or their children. And then there's this cycle, a recurrent cycle whereby it's like a family thing. A judicial appointment is given to family members. It's like an entitlement. And then based on that singular fact, we end up having the wrong, will I say, uncooked crop of people or uncooked set of people being appointed as judicial officers, being appointed as judges, magistrates, and the like. Another thing I think I would like to add is this. When it comes to judicial appointments, the fact that you're the registrar of a judge or you've been a registrar for so long should not necessarily qualify you to be a judge or a magistrate. We keep having issues with such crop of or such persons that are appointed in that manner as lawyers in practice. By next year, I'll be 20 years post-call. And I can bet you the judges that give us issues or the judges that make a very seemingly minute issue, blow it out of proportion, are normally those being appointed as registrars. So please, there should also be like a requisite training, not just your being appointed. You should at least have practiced for a certain number of years. Because I believe lawyers being appointed as judges are a better crop of judges. That's something I believe. They understand the practice better. They are less corruptible. You can't corrupt them. They are more independent. They have a mind of their own. The way and manner in which they write their judgments is even different. Now, let me give an example. Recently, I had to file terms in a matter, and the judge kept insisting we had to move into hearing. Parties have filed terms of settlement. And his registrar's excuse is that he's a new judge. Should that be my problem? If you're appointed, onus is on you to know the rudiments of practice. If parties have settled, no need for going into hearing. That's consent judgment. You adopt, everybody goes home free. But no, you are insisting we move into hearing. Honestly, I don't know. That's the plight of some of us lawyers. I do not want to elongate my response to that question, but the fact still remains. Till we start insisting, or till we have it there in our laws, that for you to be a judge or a magistrate, you need to go through legal practice for a certain number of years. We'll keep having issues with the crop of judges we get and definitely what comes out of them. And of course, their independence is not guaranteed. They are the crop of people that can easily bend to a politician, bend to threats, and all that. Thank you.
Thank you. Yeah, my lord, I think you should tackle this immunity thing from our colleague, young colleague, who said distinction between, I think, should be distinction between immunity and independence. She didn't give an example, but I think two examples come to my mind. One is in response to, like, for example, the constitutional provision that says if a House of Assembly prays to the governor to remove CJ, the NJC now says, no, we must first report to us. That's not in our constitution. No. So people are arguing that that is like an immunity. We also have had the one of the NJC's fiat that before EFCC and other agencies can investigate a judge, they have to first report to them. Then when they find a prima facie case, they can now get back to them to say, okay, you can now investigate and take action. So people argue that that seems to be conferring some immunity and not enhancing independence. Maybe that's where the young girl is coming from. So can you comment on that?
And I think she also added, she wanted to know, according to her, how the independence of the judiciary can be checked. You said something like that. They will not misuse it. And that question too is similar to the question of my brother at the back, talking about accountability. You know, how can the judiciary be made accountable? So, well, the doctrine of immunity is to give a judge at least freedom. You know, the line of distinction sometimes at a point can be very thin. You know, the work of a judge, we know, is very delicate, is very enormous, the judge needs to be protected. And that is why you have the doctrine of immunity, you know, to protect the judge. But that immunity is only in respect of the official function of that judge. So whatever a judge does in the course of his responsibility as a judge, you know, he or she is protected. And so that is immunity. But we have said so much about independence of the judiciary, which is also similar to it. The independence, when you talk about independence of the judiciary anyway, it's a very wide concept. You know, what we have discussed today is just a very minute aspect of it. You know, it's in relation to the topic that we are given. But looking at independence of the judiciary is wider than what we have discussed there. Because, for instance, we didn't talk about financial independence. We didn't talk about autonomy of the judiciary. But the discourse of today has to do with the judge. You know, judge as a judge. How can you, you know, in the course of protecting fundamental human rights, how can he secure independence to do such, to perform such functions? So, like, I try to link your question with my brother's accountability or checking the independence, I don't know how you put it, of the judiciary. There are so many ways. You yourself, you mentioned one. You mentioned the NJC. So the NJC is there. If any judge misbehave or commits any act of misconduct, a report can be made to the NJC. And you have seen how, in recent times now, either a judge is retired or a judge is suspended, a judge salary. You know, these are ways by which they should not misuse that independence. Independence does not mean recklessness. Because you are independent does not mean you can just do. You are still to be guided by rules and laws. You are still to be guided by principles. You are still to act within the principles of law. But what we are saying is you are free, you know, to perform your functions without anybody intimidating you, without anybody maybe inducing you. And at the end of the day, I mentioned about yourself as a judge. If you even have all the laws around securing you, and you are not even free from yourself. If you are timid, if you are not courageous, if you are timid, you will still end up not doing justice where you are supposed to do it. You know, so I think that is my comment. But in respect, let me just add to what my sister said here about appointment of judges. It is one of the evils that we have in our system today. And what we need is a complete overhaul of the process of appointment of judges. Professor Ojukwu mentioned something about chief registrars being appointed. As a matter of fact, in the courts today, appointment of judges among the magistrates are, they see it as a promotion, that they are entitled to it. There's hardly any appointment that will happen, you will not see the chief registrar. As a matter of fact, it's usually the number one person that they will take. Now, there was a conference recently, and I pointed out one of the problems where we have the appointment of judge being not following the due process. Our constitution itself is very faulty about appointment of judges. I drew attention to the provision of the either 6th or 5th schedule, which empowers the state JSC to appoint judges and all the processes. But do you know that the power to shortlist, that is from the rules, the rules made pursuant to that provision of the Constitution by the NJC, the power to shortlist lies with only the chief judge. So if 10 people, if 100 people apply to be judges, it is only the chief judge who will carry the list to his bedroom and decide. And of course, that stage of shortlisting, I want to see it as the most critical stage in the process, because once you are not shortlisted, you are out of the process. But now all this enormous power is conferred upon one person, and they abuse it. And that is why it is very easy to approach them. And they put, or even they themselves, they put their children, they put their whatever it is, cronies and all this. So until the Constitution itself, there should be a reform of the system about the appointment. In any event, we also know that there is no merit in the appointment of judges. It's not so much about what you know or how best you are. What we have, who do you know? Where do you come from? All these considerations, they are the things.
I won't restrict you to anything, but I will stop you today. Go ahead.
Thank you, sir. Is this working?
Yeah, it's working.
Okay, thank you. Also, for me, I wear a very beautiful scarf, which is, I'm not a lawyer, so I can go out of the box. I'm not limited by knowledge. Sometimes knowledge can actually limit us. So the first thing that I'm looking at for me is to say, when we're talking about appointments, I mean, there's something called moral justification. How many of us, can we really talk about, when it comes to judges, how they are appointed, when even the whole society, how people get into offices is somehow. So there's too much anyhowness. If we really want to focus on that, it's ensuring that it's not about who you know, but your capacity and your competence and what you're bringing in. Until meritocracy is the one that trumps everything, we continue to have all of these things, going on. Then there was the question on the ways to add potency to laws. It's just about rule of law. If everybody is subjected to the same thing, then it becomes norm. Everybody has to obey it. But currently what we have now, and which is something that even most of us are willing to use that when it's something that favors us, is to say, oh, okay, this one is my brother, it's my sister, it's from my tribe, we have the same religion. We justify a lot of things, that are wrong. And at the end of the day, our beautiful laws that we have that should be applied to everybody ends up not being applied to anybody. Earlier today, I did a tweet, and I was like, this whole Naira spraying thing is being used against the poor and vulnerable. The thing is that the law, even though we have a law there, but in essence, what it says is that it's not telling you not to spray. But ensure that when you are spraying money, you are powerful and you are someone with connections. Because why are certain children that of certain billionaires getting away with certain things? And then in Kano, a young girl has been convicted. You understand? Why is someone out there, they're doing back and forth? Is it push me, I push you with EFCC? He's saying, come and arrest me. He's saying, come to my place, the other. But other people are being, affected by it. So the thing that we need to do is that rule of law that we need to have out there. And then just quickly on the issue of whether judicial accountability, it's all about integrity. We must get to that place. And I think Prof did mention it when he talked about honesty, that honesty, you know, will save you in a lot of things that you do. In terms of, we're not saying when a judicial independence doesn't mean that it gives them immunity or they have a right to impunity and begin to do whatever it is that they want to do. It's for the system in its own way to have an independence. For example, let's take the case of what happened. Houses are being built by, for, I think, judges currently in Abuja. And in that whole conversation, a minister will stand before, I think we have the president of the appeal court was there, the Chief Justice of Nigeria was there, president of the appeal court was there, and he gleefully told them how he collected that, you know, that land from a particular company, not following due process, not following law. He recounted the experience to them, and he is using this to build houses for them. At the end of the day, this particular company, would they have any confidence to be able to come to the judicial system to be able to get that? Why is even the executive building houses for judges? Why can't the judges, you know, build their own houses? Do they have the financial, you know, autonomy to be able to do that? So these are some of, so it's different from saying that a particular judge, it's not an immunity on a particular judge for saying that, oh, they are above the law, nothing can be done to them within the period which they are there. We've seen quite a number of cases where they've been suspended, like had been said earlier. Then the final, this thing, it's on the issue of jurisprudence. I don't know if the legal system, so let me put it this way. From what I understand of the question is that cases will drag on. Like she talked about the next 20 years, you might not get anything. What are we doing with technology? The first time I was in a court, which was in that my case, my lawyer's name is Agbogayeme. And the judge was asking, okay, spell it for me, A-G-B. I'm like, why is anybody, the judge, why is anybody having to do that? Where is the case of stenographers? Why should judges up to now be writing and having to write everything? That's too tedious. Why can't we? Because I grew up, you know, reading about courts in other places where you have these stenographers, everything that is being said, they are putting it out there. So judges shouldn't be doing that. They should have people who write their own stories. It should be to listen and then, you know, get all the evidence and whatever. But now you're punishing them. Somebody has to be writing by hand everything. There's no how these cases won't get up to, you know, 20 years. Why are we not using technology? Why, for example, why don't we even have regional Supreme Courts? So I'm thinking out of the box as a lawyer, and I don't, like I said, sometimes you have freedom when you don't have knowledge. And so I'm thinking, why don't we have regional Supreme Courts that certain cases will end up there? Then there should be certain, only few cases that we get to the overall Supreme Court, and not that every case that we have is coming up there. And also, when you're choosing case, why don't we have certain, you know, using technology where people will go online? I don't know what it is called, where you put in your case, not the one that somebody will be able to pull file. Your own case that came in immediately, somebody that has been on the queue for like 10 years, you now be above that person. Because of course there will be corruption because there is human interference. If it's more technology, where if you go in, you put in your case, you are given a number, a date, it's not easy for somebody else to come in and put this thing in. So these are also some of the things, you know, that I think need to be put in place for us to be able to get, you know, the kind of things we want to see. Thank you.
As to my whom I have already given an award many years ago as a troublemaker. All right, Chid, go ahead.
Thank you very much, sirs and colleagues. I think the questions more or less address themselves, and I'm not, and the one, you know, most of them have been addressed. It's clear that judicial accountability is a matter of concern. But it's also, that's at one end, and also at the other end, judicial appointments is also a matter of concern. Now, on the issue of appointments, there are a few things that are done at the moment which should help with the question, Mr. Tojoko. Number one, the State Security Service actually has a responsibility for vetting, of security vetting of all nominees to superior courts of record. And as a matter of fact, the NJC's appointment rules require that the nominations come accompanied by the SSS report. If you look at the rules. The problem is, even the SSS report itself can be suborned. And I will tell you a story. In 2023, September, the then Chief Justice appointed his son as a judge of the Federal High Court. He did not go through SSS vetting. Now, the second in command, the second senior most justice of the Supreme Court, is responsible at the NJC for seeing through that process of vetting. When the second senior most justice of the Supreme Court at that point raised that issue, where is the report for this person? The father said, my son will not go through. As a result, he did not go through SSS vetting. When he didn't go through, the justice of Supreme Court in charge of that process said, well, if this boy will not go through, why should I subject other people to the same thing? That entire round of judicial appointments was done without SSS vetting. And you know what that means. Now, that's not the only thing. There are very little things. We're looking at constitutional amendments. If we actually could do the things that exist properly, we will not have the crisis. Sometimes we are asking, what did Aisha tell us? God will not grant us what he has already equipped us to do. We are asking for constitutional amendments. But the small things that already exist, we don't want to do. Now, Yahaya Bello wanted to appoint his wife, who had never practiced, not an academic, not magistrate, not a judge, nothing, not anything. He wanted to appoint her a judge of the High Court of Kogi State. Lawyers.
The legal title.
Sorry? Yes. Now, senior lawyers from Kogi State, senior advocates of Nigeria, 6 of them from Kogi, sued. The case was assigned to a judge with obvious instructions to deal with it in a particular way. And what did the judge say? NBA has members in the nominees, 5 of them also in the NJC. So members of the NBA should not come and be questioning judicial appointments. Before, as a member of the NBA, you question judicial appointments, you have to get permission from NBA. That's not law. This is a judgment of the High Court. And that is the second time that same judgment is being rendered. The first judge who gave that judgment was Okona Bank. In the case concerning the Abuja allocations of judicial appointments in 2021 at the FCT High Court. Now, before you appoint judges, the NJC gives you clearance. It clears for the number of judges to be appointed because you need to provide for them. Court halls, cars, budgets, the lot. In that case, they cleared for 15 judges to be appointed. That was the final round of appointments being done by an outgoing chief judge of the FCT High Court. Do you know how many they appointed? 34. They had approval for 15. They appointed 34. When you looked at that list, this one is the daughter of that one, the son of that one, the mistress of that one. The other one sleeps with that one. By the time you're finished, the judicial appointment process is rendered useless. One final point. The current Chief Justice is trying to reform the process, and she says to do that, public should be given the opportunity to make inputs. Terrific idea. But if you tell the public, everybody say what you want, who processes it? How does that go into a sensible process of decision making? The NJC does not have that at the moment. And it seems fair to assume that the only reason for this is to give all of us the impression that they are doing something. I think we should not be clapping for something designed to undermine the integrity of public participation. Public participation is important. And if we could have public participation in the process, genuine public participation, I think we would address many of the concerns that arise so far. I'll end there. Thank you very much.
Without public participation, one of our colleagues talked about accountability. In fact, my Lord has raised it here with me too. And so that's where that accountability is important, that we will have to, if you see something, say something, you know, as part of our process, especially from the bar, Yeah, and then the young colleague also asked about the 4-year gap between the case of the Ononge and decision making, and what happened. Really, they had not argued the matter 4 years earlier. They didn't argue it. They just refused to give them dates to come and argue it. So there was no judgment. That they didn't flout the rules relating to when you complete, when you take argument, or when you complete trial, and when you give judgment. They just refused to give a date to protect Buhari and his team. And then they ended up with some kind of negotiation, knowing that it was wrong for them to remove him. So what they did is they can't reverse all those things that happened, but was to give room for some kind of agreement to at least not to allow his record to be said to be a criminal while they pay him his proper dues and all that. Well, of course, he didn't get a house, because all CJs get houses and so on. So none was built for him and so on and so forth. So it was a terrible decision, as said by our presenters. It will haunt us for a long time to come. So thank you, Prof. Thank you, Aisha. Thank you, my Lord, Prof. Thank you, I didn't get your name. I'm sorry. Oh, I know you now. Well done. I know the name very much. Yeah, you're also a troublemaker. You know, very strong girl. I know you. Thank you for this short panel. And with that, I hand over to the organizers. Thank you.
Thank you very much for that wonderful session. Please, let's give another round of applause to the panel. Thank you, Professor Ernest Ojukwu. Thank you, my Lord Justice Ajile. Thank you, Professor Chidio Dinkalu. Aisha, thank you so much. Yewande, thank you indeed. As they take their photograph, may I invite to give a vote of thanks Stanley Ibe. He is a director at the ANAH Center.
Good afternoon. Good afternoon. Are there people in this room? I think the MC has done what I was asked to do, but I think it's important that I make this one point. The most difficult thing about coming to a meeting like this and hearing all the very impactful words we've had over the last 5 hours is what happens afterwards. And I'd like to make this commitment on behalf of the board of the ANAH Center that we will do something with what we've heard here. I'll tell you a quick story as I close. So 2 weeks ago, exactly 2 weeks ago, I buried my dad. And we could not get the police to come into my local government in Imo State because they said it is military territory. And believe it or not, that was a direct consequence of a judicial decision that brought in the current governor. So when we talk about judicial independence, people tend to think it is far away. It's about other people other than us. But judicial independence impacts every one of us. So it's not just about lawyers, it's not just about judges, it's about all of us. Thank you for coming. Thank you to the great panel. my Lord Justice Ajile, Chidi, Aisha, thank you to all of you, because like somebody said earlier, if you have a great feast and people don't show up, you would have had a failed event. So thank you, all of you, for coming in. Thank you, MBA branches. I see the chairpersons here. I see my teacher and mentor, Professor Ojukwu, out there as well. Thank you. Good evening.
Thank you so much, and we're grateful to God and bless God for this day. With that, we've come to the end of the CEO ANAH SAN Memorial Colloquium. Thank you for coming, and enjoy the rest of your day. Good evening.
It was indeed a wonderful year for us at the ANAH Law Practice. We're living this year with many successes and many happy for us at the ANAH Law Practice. We're living this year with many successes and many happy clients. One that we're particularly very proud of is the successful and improved second edition of the CEO ANAH SAN Memorial Colloquium, which we organized. The impact made and the fellowship we share with our colleagues is priceless. Indeed, it is not enough to be prosperous. We are happy to share in love and professional fellowship. We thank God, we thank you. Here's to greater heights in 2023.
Our law offices are like theater, where we vet new legal theories or perform corrective surgery on our jurisprudence. The law office is perhaps the most important as well as the most underrated space in the workings of the legal sector and indeed the state in general. There is an urgent need for us to revisit the structure and management of our offices.
Justice begins with